The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases and a bunch of good lawyers and law students, and we'll take them in order. In United States versus Naum, the first case, number 20-4133. Ms. McCardle. Good to have you with us, Ms. McCardle.
Thank you, Your Honor. May it please the court, my name is Eldrin McCardle, and I represent Dr. Naum, the defendant in the case below. As the court is aware, on June 27, 2022, the United States Supreme Court issued its decision in Rouen v. United States, and the United States Supreme Court granted cert on my client's case. To review this court's ruling, the Fourth Circuit's ruling issued on October 13, 2020, dismissing all of my client's arguments on appeal by memorandum decision. The United States Supreme Court vacated the memorandum decision and remanded the matter for further consideration in light of Rouen. Since then, this court has had the opportunity in United States v. Smithers to address the Rouen decision, and we believe that both the Rouen decision and the Smithers decision requires a reversal of my client's convictions in the court below.
Well, on that point, then,
Sure.
how is this case, if it is, distinguishable from Smithers?
Well, I think the difference between my case, Dr. Naum's case, and Smithers is that in Dr. Naum's case, the district court completely precluded the defense of mens rea. So the mens rea defense that Dr. Naum was trying to put forward in the trial below was that there was an except as authorized conduct. The except as authorized conduct laid in the SAMHSA regulations that allowed certain conduct by my client. I believe the Rouen case indicates that once a defendant produces, he has the burden of production, not the burden of proof. Once he produces evidence that his conduct was otherwise, except as otherwise authorized, then the burden shifts to the prosecution to prove beyond a reasonable doubt that the mens rea, that he knowingly and intentionally violated what was authorized.
Can he be, notwithstanding the charge problem in this case, can he be convicted on his testimony that he knew what Nurse Jackson was doing, which seems to be a violation?
Well, I think the district court below adeptly addressed that issue with...
You didn't answer Judge Boyd's question.
Right. That's what I'm saying, that you were asking whether or not Ms. Jackson's conduct could be attributed to him.
Correct. And notwithstanding the charge issue, can he be convicted then?
No, I don't believe he can. I don't think he had the mens rea. I think his testimony was clear in the court below that he did not authorize Ms. Jackson to do what she was doing. And in fact, in the Rule 29 colloquy, the district court specifically asked the prosecution, well, isn't that on her? I think that's a quote from the transcript. Isn't that on her? If she refused to follow the doctor's order and went out on her own, then it is on her, and she was actually convicted.
But what if, counsel, fair enough, it seems like your client said that she wasn't supposed to do that, and he did not approve it. And he may have even said he did not know it in advance, but he said he learned about it.
Right.
And so if he learns about conduct that is outside the bounds of the medical practice, and it continues and he doesn't stop it, how is that not knowingly allowing that to go forward?
I think the issue is, Your Honor, there's two separate issues. There's two prongs. Except as otherwise authorized, and what Dr. Naum was trying to basically put before the court, both in pretrial motions, in court, through his expert, and on through argument, was that he was doing through the SAMHSA regulations, which were prohibited from admission in client, or at trial, was that he was permitted to delegate certain authorities to the nurse to follow up on his orders. And so by prohibiting that evidence from coming in, the district court, in essence, precluded his entire, except as authorized, production of evidence.
So do you agree with this as a proposition? Just generally, then we'll get to how it plays out in this case. That if a doctor is aware that a nurse that operating, under him from a medical standpoint is engaged in conduct that is outside the bounds of the medical practice, that the doctor learns of it and doesn't take action to stop it, would that be a knowing violation?
In the context of prescribing Suboxone, no. And that is what's missing in the record. What's missing in the record is Dr. Helm's testimony, which was Dr. Naum's expert. We tried to produce evidence through Dr. Helms that conduct was permissible under the SAMHSA guidelines. And what happened during that whole exchange is that the district court, in no uncertain terms, stated to defense counsel, if you even go near questioning on that line of it's permissible, I will hold you in contempt. So the defense was not allowed to produce any evidence regarding the Dr. Naum's subjective mens rea as to what he was permitted to do and what he was not permitted to do.
Did you
And
make a profit?
I'm sorry?
Did you make a profit?
Oh, sure. We argued, the government filed a motion in limine at the at pretrial proceedings that they wanted to preclude all that evidence. The district court ruled that we couldn't produce that evidence because it was contrary to what the government's theory of the case was. The government's theory of the case was it was either or. They did not have to prove both prongs. They only had to prove whether it was outside the bounds of medical practice, and that's the theory that they proceeded on through the entire case.
Well, the thing that has bothered me about this case is that none of these previous cases, Smithers or Wood, nobody's dealt with this or issue. Yet we have this legal fiction out there that it can and or can be interchangeable in certain circumstances. I guess that's what the government was suggesting, but in a case like this, and makes a difference as opposed to or.
Oh, it does, Your Honor, and I think the Ruan case is instructive in that regard because they basically, the Ruan case specifically held that the mens rea required to convict a physician under 841 applies to except as otherwise as authorized. And so except as authorized is the first prong of the dual prong conjunctive disjunctive that the court is concerned about. And when...
But it didn't deal directly with the and or.
No, it did not. Ruan did not.
Conjunctive.
It did. It did not do that.
And the Smithers case didn't either.
No, it dealt with the jury instructions.
And Judge Gregory's opinion in the Smithers case specifically reserved it in a footnote.
It did, Your Honor.
Correct.
And the difficult...
But your proposition is it had to be and. That's what your position was at trial, and that's your position on appeal? The or was error.
The or was error, but more particularly, the Ruan reversed and remanded to address the jury instructions. And so the jury instructions, as everybody who practices law knows...
The jury instruction, because you said it should be and rather than or.
Well, you can't produce, you can't...
Was there any other objection to the jury instruction? It was on whether it was going to be conjunctive or disjunctive.
Yes, Your Honor. The objection to the jury instruction was along with the same objection throughout the whole trial, you cannot introduce a jury instruction that evidence is not produced. And if you're not, so in other words, you cannot, a district court can, or a judge cannot give a jury instruction for which there is no evidence. That's clear. You're not allowed to do it. It would be error to give the jury an instruction, a law instruction, when there's no facts that were presented
How
at.
about the reverse of that, going back to what Judge
Okay.
Quattlebaum, I think what Judge Quattlebaum was saying. Okay, there is evidence that he knew, but the judge just didn't charge correctly.
No, I don't think that there was evidence on his specific mens rea on what was authorized. That was 100% excluded. 100%. And if it's 100% excluded to the tune of, I will hold you in contempt if you try to come get it out of any witness, then that denies the defendant his right to a fair trial, to present evidence. And I think while the Ruan case did not specifically address it, and Smithers didn't address it, those cases were concentrated on jury instructions. But again, jury instructions cannot be given if there's no evidence. And how can you present a jury instruction to a court and say, please give this jury instruction when you've excluded all of our evidence to support it?
Well, in order to rule in your favor in this case, we've got to address the and/or issue, or not.
I believe the court does and should.
Do we have to say it was
Well,
error to?
No, I think the court
that
needs
The
to.
or was error?
No, I think,
Fatal error.
I think the court needs to look at the jury instruction, per Ruan, per Smithers. The jury instruction that was given in this case was specifically limited to outside the bounds of medical practice. There
Well, it
was
said-
no,
It said, the government may meet its burden by establishing that the physician's actions were not for legitimate medical purposes in the usual course of professional medical practice, or beyond the bounds of professional medical practice.
the problem is there's no precursor evidence that was permitted to be considered by the jury. That's the difficulty in the instruction.
Well, okay. Maybe I'm still, I guess I'm still having a little trouble, and if you could help me with this. It sounds like you wanted to introduce evidence that it was not improper to tell Nurse Jackson that she could do this unless otherwise told she can't. I think I understand that. But if that was okay to do that, and then information, your client learns of information that what Nurse Jackson is doing is outside the bounds of the medical practice, does he have an obligation to stop it? Or is he acting outside the bounds of medical practice by not stopping it?
I think he does, and I think he did address it with Nurse Jackson.
So
But that testimony obviously was not accepted by the jury.
I guess that's a little bit of my question then. If what he did once, if it was okay to do initially to allow her to go forward, and he was able to present what he did in response to that, not learning about her conduct, I'm trying to see what's the prejudice if the jury decides on, what could he say about his knowledge once he learned of it in a new trial that he wasn't permitted to do now?
Well, I think the whole premise of this entire case is summed up in the Rule 29 colloquy with the district court judge. So what can we learn? What did Dr. Naum do that was in violation of a federal law? That is the question. And I think the Rule 29 colloquy, I have a minute here, indicates, and I'll just sum up with this.
As long as you get questions, you go ahead.
Okay, so the district court said, let me stop you there. I know that what Dr. Marshalik testified about, and it was his opinion, but it has to be based on something in the rule of law. What is it? Otherwise, this is a medical malpractice case. I mean, I understand here that one of the overreaching implications of this whole case is that patients who are prescribed Suboxone at a clinic like AHC may be receiving medical care that is substandard, and that may be a violation of best practices and below the standard of care required of physicians. And in fact, I don't argue that the government in this case has put on an overwhelming amount of evidence about such patients may not be treated as patients that are in the regular primary care practice or specialty pain practice or something like that. But how is this a violation of federal law? So as to the conspiracy, you believe that part of the agreement that you've established a primary facie case about, that is Eric Drake, Sharon Jackson, Dr. Brizuela, and Dr. Naum, through the ongoing practice of advanced healthcare, did what? Agreed to do what? So that's a violation of federal law under 846 because it's outside the bounds of professional medical practice because, all right, so you think the violation of federal law is in the authority to delegate to her and doesn't have anything to do with the timing on which the defense is focused? I mean, I think a big part of the defense's case here, at least in this argument, is he actually did order the prescription. Forget whether anything was delegated or authorized. Dr. Naum ordered the prescription because that prescription was the one ordered 30 days before by him when she saw the patient. And if she violated his order, that's on her. It's not on him. The court then asks the prosecution, do SAMHSA regulations, does TAP 30 and the guidelines and the TIP 40, do they mandate or direct that a physician may not write a prescription for Suboxone without seeing the patient? Prosecution's answer, I don't believe that it explicitly says that. I think it is implicit in a just a fundamentally as a prescriber who is making an order for treatment. The court then sums it up by saying, I don't think we're going to be asking a jury to convict someone for a criminal conviction on implicit. You can link up the facts, but I think the law has to be not only explicit, it has to be unambiguous, doesn't it? It has to. You have to have the directives. And that, I think, sums up this case, because absent presenting the SAMHSA guidelines and absent presenting his mens rea, this was a medical malpractice case. And I think Ruan and Smithers talk about the jury instructions, but Ruan says the first prong is the burden of production of evidence that it was authorized is on the defendant. Well, when the defendant is not authorized to produce that evidence, how in the world can it end up in a jury instruction? How in the world can it end up being considered by a jury? And without it, it took away the mens rea, and therefore, he was convicted. I think the Supreme Court, United States Supreme Court, recognized the importance of the facts of this case. While they didn't address the and/or, they recognized the facts of this case.
So you think this Ruan's more helpful to you than Smithers?
I think so. I think they're distinguished because Smithers was more, I mean, it was 800 and some counts, and it was all on a jury instruction. And this was more than a jury. You can't have a jury instruction when you don't have the evidence. And that's really why this case is distinguished.
Thank you. You've reserved some time.
Yeah. Thank you, Your Honor.
Ms. Herney? What's the government think about this?
Good morning, Your Honor. May it please the court, my name is Eleanor Herney and I represent the United States. And I think I'm going to deviate a little bit from my outline and try to address some of the questions that came up today before circling back. So the first thing that I would like to touch on is the mens rea issue and how it ties specifically to the jury instructions in this case. And I think one of the things that we can start with today is that below the evidence that has been identified as being precluded, which prevented Dr. Naum from being able to argue that his behavior was in fact authorized, wasn't directed at his subjective knowledge. So there's two categories of evidence there, and the first is we have the Vermont and I believe the Massachusetts models, and it deals with office-based opioid treatment. And the exclusion of that evidence wasn't related to Dr. Naum's statement or proffered testimony that he believed he was acting in compliance with those models. Those models were just irrelevant because the facts were wholly distinguishable. In the both Vermont and Massachusetts models, the care-based team approach was completely different. There were nurse practitioners involved, similar to Dr. Helm's practice, Dr. Naum's expert witness who testified that he actually has a nurse practitioner who he works with, and nurse practitioners were able to independently prescribe
Now, where's the
Suboxone.
mens rea charge in this indictment?
Where, I apologize, Your
Or
Honor.
where'd y'all allege anything about knowingly in this indictment?
Your Honor, I believe that it's in the standard 841 language,
Well,
although I don't have it
you're
in.
charging him with 841, which doesn't have anything in it about this stuff about the legitimate medical purposes or bounds of professional medical practice. That's not in 841.
No, Your Honor,
But
however,
you're
it-
charging him with a crime under 841.
correct, Your Honor, and I believe that that's where once evidence of
All
authorization.
that comes out of regulations and stuff created by the Board of Medicine. Isn't that right?
I
And
believe,
you argue that it gets in there under this authorization clause
that's correct, Your
later
Honor.
on in 841.
And I believe that authority was delegated to the Attorney General fairly broadly, and then the regulations were promulgated under that. So that would be,
What did this Supreme Court case, Loper Wright, have anything to do with this?
well, Your Honor, the
I mean,
government's,
you're trying to prosecute him under some regulation written by some government lawyer,
so, Your Honor, the government's
or a
position in
doctor, or somebody.
in terms of Loper Bright would be, first, obviously, it has not been briefed by the parties, and second.
No, I know it's not briefed by the parties, but it's the law of the land.
Yes, Your Honor, and I'm happy to
No.
address it as best I can. So in terms of Loper Bright, I think we would only be in a situation in which Loper Bright had a role in this case if we were disputing, the ambiguity of the sentence. We simply disagree with what that regulation means between the parties as to whether
I
or
didn't
not.
mean to get you off track with that, right. I'm just throwing that out. But what you do need to focus on is how you get around Smithers.
Yes, Your Honor, and
How you get around Ruan, or whatever the name of it is. But particularly Smithers, that's recent authority in this court. And it's a very thorough opinion. It's a unanimous opinion. And it's a similar case. And they upheld the convictions of the doctor.
Now, I apologize, Your Honor. I believe in Smithers, did they vacate the
Went
conviction?
the wrong way.
Yeah.
I got the wrong way. They threw it out.
It would certainly be different for my
They
response.
threw it out. Strike that.
I believe Smithers is actually,
They reversed it. Judge Gregory wrote it and they reversed it.
I believe Smithers is actually quite distinct from this case for several reasons.
What did they
and,
say about the and/or provision?
the and/or provision was left open. It's just a question in Smithers as to the subjective intent. And in Smithers,
That's right, but they said you had to have, in footnote 5, he specifically said that. But what about the allegation of knowingly? He said you need an allegation of knowingly. You may be able to get around this and/or if you put knowingly in that instruction twice.
absolutely, Your Honor. And
If you knowingly, before the legitimate medical purposes, and knowingly before the bounds of professional medical practice, but you don't have it in there.
no, Your Honor, but we believe that in this case, and as the government's, I believe, second supplemental response brief noted, we're not disputing that there was not the subjective knowledge instruction as Smithers set forth, that there has to be some directive that the knowledge authorization goes just beyond the act of
And it's not
distribution.
alleged in the indictment. The knowingly is not alleged in the indictment, the way Judge Gregory explained it. You don't have the allegation that he said could save it, the and/or thing. You don't have it in there. Are you conceding that there was error in this situation?
Your Honor, we are conceding that there was Ruan error in the jury instructions.
You are.
Yes, Your Honor, and that was the position that the government took in the second supplemental response brief.
And you're contending that it's harmless error.
That's correct, Your Honor, and that would be where I appear to be directed to head next, and I'm happy to do so.
All right.
So the government's perspective on harmless error is that,
Just before you answer, is it harmless error or is it prejudice that under clear error? In other words, whose burden is it to show whether it's either harmless or non-prejudicial?
Your Honor, I believe that typically the answer to the question of who the burden is on is, tends to be the government in this situation, and I believe that's how we've approached it.
Okay.
I don't think that we have briefed the question of whether clear error applies and where the burden is. We originally argued plain error.
That's what I meant, plain error rather than clear, I'm sorry.
And I believe after Judge Gregory's decision in Smithers, we backed off on that perspective in his analysis of how mens rea and the and/or question are, to some extent at least, intrinsically intertwined with each other, not to
Okay,
use.
Well, go ahead then. So you concede error, Ruan error, you concede it's your burden to show harmlessness. So what's your position on that?
So our position on harmlessness is that the uncontroverted evidence at trial shows that even if the jury had been expressly instructed that the government must prove not only that the prescriptions were unauthorized, but that Dr. Naum knew the prescriptions were not authorized, a reasonable jury would not have reached a different result. And specifically, if we look in this case even only at Dr. Naum's testimony, as I believe this court previously identified in its questioning, Dr. Naum testified that he knew he was not permitted to delegate his prescriptive authority to Nurse Sharon Jackson, who is a registered nurse. He testified that he knew Nurse Jackson was overriding his instructions to wean or decrease patients' doses. He testified that he confronted Nurse Jackson about increasing a certain dosage, but to no avail. And he testified that once Nurse Jackson did so, and I'd note using Dr. Naum's DEA-X number, that he couldn't turn the patient away. Dr. Naum testified that specifically he was not in agreement with Nurse Jackson doing that he was happy that, quote, they could get treated, but was I in agreement with her doing that? No, end quote. And I would note, as Ms. McCardle did note as well, that the jury did not acquit Dr. Naum of the conspiracy count and clearly did not credit his testimony that he wasn't in agreement with Nurse Jackson.
But Ms. McCarthy, she came at this case a different way than I had thought about coming in. She says that the exclusion of that evidence by the judge is what the error is. Is it, because then he went on to charge something that they weren't entitled to contest.
I would disagree, not with your characterization, but with the argument itself, in the sense that I believe that is recasting an issue that was not argued in that way. So as I was stating earlier, when discussing the Vermont and the Massachusetts models, and then moving into the opioid-based treatment regulation specifically, which I believe was that subset regulation that was referenced, and which this court in its prior panel opinion, pre-Ruan, acknowledged was not applicable by its terms.
Was the exclusion of the evidence based on it's not relevant, it doesn't meet the Daubert test? Why was it excluded?
I believe it was a combination of the two, that there was a hearing on the matter, but I think it really did come down to that Rule 403 question as well as relevance, because in...
And there was a pretrial motion in limine
Yes, Your Honor.
on this? So you
Yes.
litigated it before the trial started?
Yes, Your Honor. And it was raised multiple times throughout the trial as well. But I would note that the argument didn't deal with whether or not Dr. Naum believed that these regulations or that program model actually applied to him. It was solely about whether or not it could be presented. And in that sense, it wasn't really tied to Ruan in any way. Obviously, it couldn't be, as it predated it.
But I think the argument is, that there would be testimony that it is proper to delegate authority except as otherwise authorized, that doing that is not, contrary to the law in any way. I think that's what I'm understanding, your colleague to be saying. And that the inability to present that evidence, that if that's what the standard of care is, And that's consistent with what Dr. Naum did here. So his delegation is, not even contrary to the bounds of medical practice, and certainly not knowingly. So I get your point that they weren't talking about his subjective intent, but if the testimony was that he could do this, then it wouldn't even be wrongful, much less knowingly wrongful. And so I guess I kind of understand that point as to why Dr. Naum would think that would be relevant. I think the real question, though, or a question, is what you, I think, were getting at. Even if that comes in and it's okay to set this framework up that she's going forward unless otherwise authorized, he did become aware of conduct that he didn't agree with. And what happens then? Is that what you're saying?
That's getting very close and better articulated, Your Honor, but yes. And what I would note as well, I think there's two parts to it, is first, much of that evidence was still effectively admitted through Dr. Helm's expert testimony at trial, where he testified regarding the use of nurses.
Right.
And
But
further,
Dr. Naum never said, it's really interesting, and I was frustrated at first, because I was like, why aren't y'all asking about knowledge? And then I was like, okay, Ruan was, predated all this, so I've kind of, like, I understood it more. I think I understand it more. But Dr. Naum never said, I don't think, anywhere explicitly that he said he didn't agree with what the nurse did. And then he said, but I didn't want to send the patients out on the street. And there was really not a discussion about whether he knew what she did was outside the bounds of medical practice. Now, I think you could read it and say that's implicit in what he was saying. But it was never explicit in what he was saying, at least it didn't seem that way to me. And it kind of shifted as to whether it was with a clean heart, if you will. I was going to not put the patients in a bad situation. So if it wasn't explicit, can we really say this error was harmless?
Your Honor, I believe that we can in this case because, again, we can look past just his testimony, the actual oral testimony itself, and also look at exhibits that were presented. We can look at the letter to the West Virginia Board of Osteopathic Medicine and see that, the way he represented Advance to be running was not consistent with how it was actually running. And that is another point of distinction from Smithers as well, which is in Smithers, when the doctor in Smithers presented his own case, he had, as I believe Judge Gregory identified, an innocent explanation for each deviation. And of course, there's always the argument that this excluded evidence could have been that innocent explanation. But I would note—
Here you wouldn't let him testify. In this case, he wasn't allowed to testify to that because of your exclusion, motion in limine.
Well, Your Honor, my recollection of the motion in limine, and unfortunately the size of the joint appendix has precluded it from being present with me, was that it wasn't necessarily that Dr. Naum was going to testify that he believed that his behavior was in accordance with this model, but that this model existed. And there were key distinctions between those models and the way Advance was run. And part of that, as I believe I already identified, came down to how the collaborative care team was built. So—
Are you conceding error on the evidence question? Or something else?
I apologize, Your Honor. Which evidence question?
You're conceding error on mens rea.
Your Honor, the government's position is that we are conceding error in the sense that the Ruan subjective intent instruction was
That's what
not
I'm
given
talking
to the
about.
jury.
But that's tied into that, she's saying that's tied into this pretrial ruling. Are you conceding error on the evidence question?
As to—
You concede that it was preserved, it was litigated, pretrial. So your error concession doesn't cover that or does cover that?
No, Your Honor, because I don't believe that that was, looking at that specific subset previously, as I believe we noted in our first supplemental brief, we weren't actually sure as the government what this evidence of his subjective knowledge that was excluded was. We assumed that it was likely the Vermont models, and we disagree that the court's ruling regarding, or not even ruling, but the prior case law regarding the objective standard was really what barred the admission of this evidence.
Well, don't you think that it makes a difference in this case, when that evidence is barred from being considered, and then the judge charges the jury and uses or as opposed to and when on the other side of or, there's no evidence to give that charge. So it looks like it makes it way too easy for a jury to convict.
Setting aside the question of the and/or, which I understand is really inherent in this, and were the court to wish to decide it, the government would appreciate the opportunity for additional briefing on that specific issue. But
Well, my follow-up was going to be, why don't we just settle this now? Why should it not be and in a case involving a doctor, where clearly both sides of that charge have to be proved beyond a reasonable doubt?
Well, Your Honor, believe that under various different statutory interpretation principles and looking at this, that or is also an acceptable construction. And it's consistent with how it's interpreted elsewhere, including in its...
I understand that. I used the word legal fiction a while ago. That's what it is to me. I know it's interchangeable. But in a case like this, why should it be not interchangeable?
Well, Your Honor, I believe that determination, I don't think that we need to reach that in this case. And one of the reasons for that is Dr. Naum's trial testimony and much of the evidence that was presented is inconsistent with the concept that his testimony might be different if he were permitted to present evidence of his subjective good faith. Of course, he might still be able to state, I previously went to one of these continuing medical education seminars, and I met with somebody who works at one of these models in Massachusetts. And, they stated they receive state funding, and they get to use nurse practitioners and all of this different information. And that testimony would simply not be consistent with the testimony that we have on the record. And of course, I think there's, an opportunity to read the ambiguity there and to look at it in different ways. But at the end of the day, he did testify that he knew that she could not do that.
Yeah, what's the interesting thing, he said he learned about what she did. He said he disagreed with it. I agree with you, the statement to the medical board would suggest he not only disagreed with it, but he thought it was, that type of practice was not allowed. It's not really clear about what he did once he became aware of it. Although he, there was testimony about it, didn't leave the practice and I didn't want to have the patients on the street. I'm wondering if there's enough there where we can say, when the rules have been changed, the Supreme Court changed some rules, we've changed some rules, that, if it's not explicit in the testimony, should he have a chance to make his case on subjective knowledge, if those are now the ground rules? I mean, if it was, it seems like it's got to be almost undeniable that it was not with knowledge for us to not give him a chance to, make his argument under the new rules. And I guess your argument is that it's undeniable. I guess that's the big question.
This is convenient timing. I would like to answer.
You answer all the questions you get from the court.
Absolutely.
Go right ahead.
And I would say that the evidence in the record is undeniable, but
would you agree, I want you to finish that, and I know, would you agree if there's some evidence that it's knowledgeable and some evidence that it's not, and maybe even if there was some evidence that was precluded that it's not, that he would deserve then to be able to have, a retrial with the correct rulings. It's not like, is there sufficient evidence? It's got to be clear that he couldn't, he couldn't avoid a finding that it was knowledgeable.
Your Honor, in that specific circumstance in which there was some evidence on both sides, similar to that in Smithers,
Right.
I would agree that under the harmless error doctrine, that that's precisely what would be required. I just simply disagree as to the weight of that evidence.
I appreciate it.
And if I could just briefly attempt to summarize.
Now, I want to ask you, again, exactly what you're conceding error on. I want to tie you down on that, the government down on that. 'Cause it seemed, you go ahead and tell me what it is.
Your Honor, the government is conceding that Dr. Naum's, the jury instructions in Dr. Naum's case did not incorporate an element of, or expressly indicate that there had to be knowledge as to the authorization.
Are you conceding that that the restriction on his testimony pursuant to the motion in limine, one that Judge Quattlebaum was talking about, was erroneous?
No, Your Honor, the government is not conceding.
So you're not conceding that part?
No, Your Honor.
Okay, but if they're tied together, how do you make that distinction?
Your Honor, I would respectfully submit that they're not tied together. There is an objective knowledge, there's that objective standard, and I don't want to use the phrase standard of
Well, I think
care.
Judge Gregory's opinion said that applies to the second prong after the or, the bounds of professional medical practice. That's the objective. That can be objective. But the first part has a subjective part to it.
Your Honor, was that the portion?
In any
of-
event, isn't that right?
I believe that there was a portion of the opinion in which he noted that there is a subjective connotation to, I believe, legitimate medical purpose, and that it could have been cured with a specific intent instruction, which I believe.
And that's the first prong, legitimate medical purposes. The first part of it, the first alternative before the or.
Yes, Your Honor.
That has the subjective component. And that's what he wanted to offer this evidence on that you all had stricken or barred.
Your Honor, I would submit that the evidence that Dr. Naum wanted to submit was regarding essentially the general objective standard of care. He wanted to submit evidence that the use of nurses and, less doctor oversight, more of a collaborative care team was accepted elsewhere. And that testimony came in through Dr. Helm, but the specific testimony regarding these models that had state funding, they were tied to state regulations, and the specific SAMHSA information regarding opioid-based treatment programs, which, again, as this court's opinion in this case prior to Ruan noted, is simply inapplicable. Dr. Naum was a data waiver exempted physician. It was not an opioid-based treatment program under that. So in ruling on the motion in limine, the district court exercised its authority to exclude evidence that was simply not relevant on its face as to the objective standard for physicians.
Which goes to the second prong after the or.
Your Honor, I believe,
Under Smithers.
I think that would be a fair characterization of it as the two kind of dovetail at points. If I might briefly make my remaining argument.
Go ahead.
Okay. Very briefly, Your Honor, the government would submit that regardless of Ruan, Dr. Naum's conviction for conspiracy to distribute Suboxone, as charged in count 22, remains valid because the jury instructions as to that count effectively incorporated knowledge as to the unauthorized nature of the
Are you
prescriptions.
limiting your argument to 846 charge? You say conspiracy.
Yes, Your Honor, and that would,
You're not, you're conceding error on the 841 charges?
Your Honor, I believe that this is the error that we previously discussed post-Ruan regarding the specific intent.
But he was convicted of 841, wasn't he not?
Yes, Your Honor.
So I'm not sure I understand what you just said. And I'm sorry if it's on my point. Are you saying that in the conspiracy charge, you're not conceding error, that the charge was okay?
Your Honor, in the charge itself that was given to the jury, Dr. Naum effectively, for the jury to find him guilty beyond a reasonable doubt, had to find that he knowingly entered into an agreement to distribute substances without authorization. And that specific, and I'd like to make sure I've got my language right, as I will not have a chance to clean it up, and I would note I have seriously run over my time, and I apologize.
We want to get this right this time.
So specifically, the jury was instructed as to the elements of the conspiracy count, that Dr. Naum could be found guilty only if he and another person had an agreement to distribute Suboxone outside the bounds of professional medical practice, and that he knew of the agreement and that he joined it, requiring the government to prove that Dr. Naum knew that the prescriptions that his co-conspirators, and specifically Nurse Jackson, issued were unauthorized. In other words, Dr. Naum had to know that the prescriptions were outside of the bounds of professional medical practice.
So your concession of error only relates to the conspiracy conviction, 846.
No, Your Honor. So separating it out in terms of the instructions and looking
You're
at
conceding
Smithers.
error on the 841 conviction.
Yes, however, we are maintaining steadfastly that any error was harmless.
I understand that you want to say it's harmless, but you do say it's harmless. You absolutely, the government says harmless error. We hear that from the government a lot. We're familiar with harmless error. We got some of these prosecutors are experts in harmless error. I was one of them at one time.
So in summary, the United States submits that this court should affirm Dr. Naum's convictions in the entirety, but regardless of the court's ruling on the 4 substantive distribution counts, Dr. Naum's conspiracy conviction stands separate and should be affirmed because of those jury instructions, which required a finding as to Dr. Naum's
So
knowledge.
again, you're limiting your argument, you're trying to limit your argument to the conspiracy. You said that conspiracy conviction should be sustained.
So, Your Honor, the government's position is that all of the convictions below should be affirmed, solely that there's a separate independent basis for
You're
the
just saying that on
conspiracy.
the conspiracy conviction, you're not conceding that knowledge was not charged. You're saying the conspiracy conviction, you think sufficiently charges subjective knowledge.
Yes, Your Honor.
So why don't you just leave it at that? Standing on your conspiracy charge and concede the substantive charge? Because you might get an opinion you might not like, or the government across the board might not like. Because this has been an ongoing battle between the pill doctors and DEA, and you might get a tough decision.
I do appreciate the warning, Your Honor. The government, if there are no further questions, would sit back down with no time to cede.
That's what I'm on. You satisfied?
Thank you. Yes, appreciate it.
Thank you very much, Ms. Herney. We appreciate it. Ms. McCardle?
Lots to uncover there. The first thing is with regard to standing on a conspiracy instruction versus the substantive. I think Smithers addressed that. If the prejudice related to count 1 spilled over to count 2 and they can't be separated. I think Smithers specifically addressed that in the opinion. Knowingly entered into an agreement, he and another person, I think the government indicated and quoted from the transcript that Dr. Naum did not specifically agree with Nurse Jackson's conduct. And
But he definitely said that. I don't think
Yes.
there's any dispute that
Right.
once he was confronted with questions about whether he agreed with what she did, it was pretty clear he didn't.
Right.
The question then is, what did he do with knowledge of that?
Right.
And a lot of your, I think, as I'm understanding it, the excluded evidence would go with the issue of whether it was okay to allow her to go forward and kind of go at this unless he says no.
Right.
But at some point, if you learn that the nurse is acting contrary to the bounds of medical practice, which he seems to have done, it seems to be, then the next question is whether allowing that to continue
Right.
is a knowing violation.
Right.
And I think that's what government's saying is, they're probably not conceding it, but I'll give you everything up until the time he learns of it. But once he learns of it and doesn't stop it, how is he going to say it wasn't a knowing violation then?
Well, the question then becomes, is Nurse Jackson's conduct in not stopping attributable to Dr. Naum?
Well, does
And
he not
that's-
have, as the doctor overseeing the nurse, the responsibility to stop knowingly?
Yes, and I think the key point there is he would say, wean this patient off. All right, so weaning, in other words, this whole case of Dr. Naum is on Suboxone. It's on a medically assisted treatment. It's not on prescription of opioids. It's not on prescription of fentanyl. It's not on prescription of oxycodone. It's on Suboxone, a very drug that is used to wean people off. So that's what that's why these clinics exist. So I think you have to weave that in with the do no harm Hippocratic oath. Once, and this is where the difficulty lies in using 841 to prosecute doctors under regulatory provisions that are not passed by Congress, that are imposing strict liability.
But aren't you're getting, I think, tell me if you're right.
Okay.
I hear what you're saying is there's a legitimate question about when Dr. Naum learns that patient A that Nurse Jackson has made a change, issued a prescription or made a change in it, and learns of that, he knows it's wrong. And there's a legitimate question about what to do next with respect to patient A. Do you kick her out?
Right.
Or he out?
Right.
Or do you do some weaning thing? I think that is fair, but I think the government's position is not about what you do to patient A. The point is, did you stop Nurse Jackson from doing that with other patients?
And to answer your question, Your Honor, this was a period of eight years. Dr. Naum worked part-time at this clinic, started out with 55 counts, 39 were severed. The remaining ones, I think there were 10 left. Out of those, the government dismissed more. He went to trial on 6. One of them was, he was acquitted because the pharmacy made an error, and so 5 patients in a total of, I think, 800-something is what we're talking about in this case. 5 patients in the course of 12 years that this indictment covered. So strict liability, I think, is a problem, especially when you omit the, I think counsel talked about the Vermont and Massachusetts models. They're very different. Dr. Helms was not allowed to testify to that model that he performed medically assisted treatment. And so I think that's relevant to the subjective knowledge. The letter to the board I have to address because
Now, he was convicted on, you said 5
patients,
5 counts.
well, it related to 5 patients out of the entire
He
time.
was convicted on 841 counts and an 846 count?
Correct,
Okay.
correct. The letter to the board, the government takes a position that he misstated his position to the board. The board did not take any conduct to reprimand him, didn't take his license, didn't.
Which board was that?
The Board of Osteopathic Medicine.
I know there's another board for the Board of Medicine.
Right, he's not under the Board of Medicine.
Right, there are 2 boards in West Virginia, right?
Yes, yes,
One's for osteopaths, one's for
correct,
MDs.
correct.
And those boards write these regulations, or the legislature?
No, the board did not write the regulations, the legislatures didn't write the regulations, these were
The
put
board
together.
wrote them?
Yes,
And
the
they're
board,
talking-
board puts together
Okay.
regulations.
Yeah,
And
that's
then,
what I thought.
and then what
But
was,
we're talking about the osteopathic board, not the medical doctor board.
correct, because that's what he's under. And the osteopathic board, that's what ended up going to trial, is that Dr. Naum did not see the patients within 6 months of prescribing the Suboxone, so he didn't re-see the patient. So after the government went through all of their evidence, they found 5 patients over the course of the entire time. And Dr. Naum was making $3,000 a month over 12, he made $360,000. He wasn't getting the money. The nurse and the other person were. So we believe, Your Honor, that the subjective knowledge is crucial in this case, as per Ruan and Smithers, and that Dr. Naum is entitled to a fair trial and that his convictions must be reversed.
Well, let me add, because I obviously, I missed the way he was thinking about it coming in. There has been a battle between DEA and PhilDOT. The question is, in my mind, was that evidence excluded because it's irrelevant, or is there some Daubert issue that says it's not admissible?
There was no Daubert issue, Your Honor. The evidence was excluded because the district judge believed it would confuse the jury as to what the real standard was, the subjective standard for the defendant, and it would confuse the jury by admitting that evidence. That's why it was excluded. And so,
Didn't the district court, maybe this is briefing, not district court, so correct me if I have this wrong, but wasn't there a discussion about whether that standard applied at all to this type of practice?
I think the district, in my,
So it's not just confusing, it's relevance, right?
well, I think the district court said it was splitting hairs between what was the
Which word
applicable
did you
standard.
use?
I'm sorry?
What was the word?
Splitting hairs?
Splitting hairs.
Hairs,
Okay,
yes.
that's what yeah,
Yes,
splitting hairs.
yes.
That's what the district court said. You're quoting the district.
No, I'm not quoting the district
You're
court.
not,
I think, I said it's my opinion
This
that
is-
the
this
district
is-
court was splitting hairs with the
This is
Vermont
like the
model and the
McCardle
Massachusetts. It is a McCardle thing,
Yeah,
yes.
all right.
But am I right that the district, you may characterize it splitting hairs, maybe it is, I'm not getting into that right now, but the argument was in part that it was not relevant, and or am I wrong there?
No, I think it was, I do.
I know you thought it was
believe,
relevant.
no, I think that, I'm quoting the district court and saying it would confuse the jury to put both of these standards before them. I think that the confusing the jury were words that came out of the district court's mouth.
Thank you.
And just as a footnote, in a subsequent case before another district court judge where that first part of evidence, authorized, except as authorized language and evidence was allowed to be put in, a week later, the defendant was acquitted.
Thank you, Ms. McCardle, and I know my records show you're court appointed?
No.
You're not?
Oh, yeah, actually, yes, I am. The reason I
Are you
say
court appointed or not?
I was retained below, court appointed on.
That's what I thought. And I wanted to thank you for your work as a court-appointed lawyer in this case. We couldn't do our work without lawyers like you. We appreciate it. And we'll come down and greet counsel, and then we'll go on to the next case. Is that all right? You may be seated. Our next case this morning is Naviant Solutions versus Loman. Mr. Calhoun? Welcome to the Fourth Circuit, Mr. Calhoun.
Thank you, Your Honor.
Good to have you with us.
May it please the court, George Calhoun, IFRA, PLLC, on behalf of the appellant, Naviant Solutions LLC. I am happy to be here. The last time I argued before the court, it was over Zoom, and this is much more pleasant. This case involves the misapplication of the standard for a Rule 50 motion and improper removal of a jury's verdict. This case involved RICO, fraud, tortious interference. We had a week-long jury trial in August of 2021. The jury found that the defendants had engaged in a fraudulent RICO conspiracy that injured Naviant by using fraudulent marketing practices to entice borrowers into a phony debt relief scheme. They had further attempted to further this scheme by targeting Naviant with manufactured TCPA claims. The jury carefully considered all the issues, deliberated for 4 days, asked multiple questions. Notably here, the defendants are not challenging the critical instructions. The district court, however, deferred ruling on the post-trial motions for 2 years. That alone should give an indication that the district court wasn't certain about what to do here. And typically, a JNOV decision should be for cases that are clear, that are easy because there's no evidence. And that's really the standard that's here. The Seventh Amendment places great...
Well, I mean, you gotta be a little careful, and, I mean, the 2 years, I mean, we you know, that's a bit dangerous for us to think about outside events. I mean, we look at orders and things that happen within the judicial process, don't we? I mean, you're asking, you're suggesting time indicates it was a closer call. Maybe that indicates that. Maybe that indicates something else.
Fair enough, Your Honor, and we'll go into the actual opinion and decisions,
kinda-
because I think that's where...
Make whatever argument
Yeah.
you want, but I think it'd be more effective to stick to the merits of it.
Fair enough, Your Honor. The Seventh Amendment places great constraints on a court's authority to overturn a jury verdict. And the standard is either reasonableness or substantial evidence standard. And so, and that's a more stringent standard than the clear error standard when a judge makes a factual finding. So what we have here is, for this court to decide, did the jury make an explicit or implicit finding on the issue? And if there's any record evidence to support that finding. If the answer to those questions are yes, then you have to reverse. The ultimate ruling by the district court that we contend is error here is that the district court ruled that Naviant caused its own injuries by violating the TCPA because the TCPA litigation was not sham litigation. This is error for multiple reasons. First, there was no evidence in the case that Naviant violated the TCPA. In fact, that was an issue that was discussed in motions to eliminate before the trial. It was explicitly excluded. We could not, the judge did not allow evidence about compliance with the TCPA. Whether or not Naviant violated the TCPA was not an issue in the case. She said that repeatedly. She denied any testimony that was going to whether or not Naviant was in fact complying with the TCPA. So in excluding that issue from the case and then basing her ruling on causation on the allegation that Naviant in fact violated the TCPA, she committed error. In fact, there was some evidence in the case that Naviant did not use an auto dialer, which would have precluded a finding that Naviant violated the TCPA. There's simply no evidence to support the finding and conclusion of the district court that Naviant violated the TCPA. That alone...
But that is the issue that, did the district court say, I don't think the district court's conclusion was that there was or was not a violation of that statute. The district court's conclusion was that in order to get the damages that you put up, which as I understand it were just attorney's fees, they weren't like, that was the evidence that was put in as attorney's fees. As I recall, the district court said, if that's your evidence, the only way you're going to get attorney's fees as damages is if the litigation was sham evidence or sham litigation. And without deciding whether there was a violation or not, the district court said there was at least, enough evidence presented that it wasn't sham or frivolous or, bad faith sort of litigation. Not who was going to win or lose if there was ultimately a specific claim there.
Well,
So isn't that how it was resolved?
A couple responses to that, Your Honor. One, I invite you to reread the district court's opinion because there was an express statement that Navient violated the TCPA.
Okay.
So I disagree with that characterization. Second, we also presented evidence Navient was damaged by loans that weren't repaid and by settlements that it made. So the issue of attorney's fees was one element of the damages, but one part of the damages that we put on evidence and proved was that Navient was damaged when these borrowers were instructed by the scheme participants not to pay their loan. In our damages calculations, we only used the individuals who eventually went into litigation just as a matter of convenience. But we put on evidence that when a borrower was instructed to stop paying and stopped paying, that damaged Navient, it went to the bottom line of
But you
Navient.
didn't, well, I mean, you made that argument for sure, that that borrowers were instructed not to pay. But did you like say, okay, here are our damages, you know, in the record, we have what you put up as damages. Is there a calculation? Is there a witness who said, here are my attorney's fees damages, here's my non-payment damages?
For the non-payment damages, what we had was the amount of the loans that were ultimately not paid or written off. Right? So there was a column, I can give you the exhibit number, I have to dig it out, but I'll do that when my opponent's speaking.
I'd like the J sites where you
Yeah.
put up damages other than attorney's fees.
Yeah, I'll give that to you.
You can
Your
do
Honor.
that on the rebuttal.
The second piece of this is the district court said that you only get the damages if it's not sham litigation, which is incorporating, the defendants had made an argument that Norah Pennington applied to the litigation. As an aside, whether Norah Pennington applied would only apply to matters that were in litigation. It wouldn't apply necessarily to private arbitrations, which is the vast bulk of these cases. But she seems to have merged that Norah Pennington sham litigation argument into her ruling. She doesn't discuss Norah Pennington in the ruling. The district court didn't do that. But she's adopted the sham litigation concept, which is not one that appeared in the causation instruction or anywhere else. But in doing so, she didn't apply this court's sham litigation standard from the Wall-Chapel South decision.
Well, let
She-
me ask you this, then how should we analyze the pre-litigation conduct under Norah Pennington? I mean, how should we do it? Or do we have to?
I don't think the pre-litigation conduct has anything to do with Norah Pennington. I don't think Norah Pennington applies to that. So what you have here is we have a RICO conspiracy found by the jury, and you have a series of conduct. We likened it to a pipeline where the participants in the scheme, first the marketers, would go out and send phony marketing materials to borrowers, entice them in. They would then meet with another customer service rep, an attorney. The whole plan, is in the evidence, was that they didn't have a plan, that the plan to resolve this debt was either through manufacturing a lawsuit or by the statute of limitations. They never actually did any debt relief work. All of that work,
So you're saying, let me make sure I understand. There's no pre-litigation conduct that we should analyze under Norah Pennington, is that correct?
Norah Pennington only applies to petitioning activity, right? It's a First Amendment concept. It applies to petitioning the government. That applies to both administrative, judicial, other branches. But non-litigation activity, things that they're interacting on a private basis with consumers, is not protected activity. It's not petitioning activity. So only once they take the step to initiate litigation would Norah Pennington come into effect. And a lot of the conduct that is at issue in this case was not, even under the concept of representation. There was evidence that the Loman defendants had a call center that would deal with all of these cases that were coming in. They would instruct them on how to revoke consent under the TCPA. They would tell them about the importance of getting calls. They wouldn't take their case if they were still paying. There was some emails suggesting that they did in fact instruct them not to pay. That was all in an effort to create a factual situation where they could even begin to bring a case.
So
And that was before an engagement agreement was signed.
So was the underlying litigation litigation baseless?
Oh, very much so, we believe, Your Honor. There was a dispute about that. But in fact, Navient was not using an auto dialer, was not violating the TCPA. The basis, the ultimate crux of all of this is the only way they had to continue this program where they were collecting millions of dollars from consumers was to manufacture TCPA claims. So they would testify in arbitrations, they would have their borrowers testify in arbitrations, they would call Naviant and say we didn't want calls. But ultimately, this all depended on their wanting calls. So there's evidence in the record from one borrower, for example, who called Naviant, changed her phone number from a landline, which isn't subject to TCPA, to a cell number, and then stopped paying, in the effort to induce calls to her cell phone. So they wanted these calls. So whether that's a Spokio standing issue or something else, in fact, they took steps to increase the numbers of calls. This was not a real dispute where they were going out and trying to help people who had calls they didn't want. They wanted the calls.
But let me explore an issue that is a little bit different maybe than the claim as to the overall, scheme as you characterize it. Because, and my reason for doing that is there may be, if we, agree with you about the scheme being improper, then under RICO at least, the damages need to be causally sufficiently connected. Yeah, you're going to talk about the non-attorney's fees damages, but there's an issue about whether the attorney's fees damages would or would not be sufficiently connected. I know you disagree with that, but but let me get to my other point so we don't get too off track. One of the claims that you have is just, regular common law fraud, and it seemed like you introduced evidence that the Loman defendants made representations to your client, that they represented borrowers, debtors, and the borrowers said they didn't know anything about them. Even if the RICO claims were even if the order is sufficient on the RICO claims, is there evidence that would support the fraud claim for making representations, to your client that they represented people that they did not?
So the representations that they made were, they filed lawsuits without these people's knowledge.
Right.
I won't go so far as to say they didn't know who they were, because
Didn't some witnesses says someone else is our lawyer, not you?
well, there were yes, because a lot of them thought they were represented by the other lawyers in the scheme, David Mize, for example. They didn't know who Loman was.
Right.
So there is evidence of that the jury considered. And I think that's sufficient on the fraud piece. There's other evidence that they were filing these lawsuits without their knowledge, that they were serving discovery responses that the individuals hadn't seen. There was some evidence on that. We think that's sufficient on that. And if you go back to the Wall Chapel South standard, if you're looking at whether this litigation was a sham and tying the fees to that, the jury was instructed properly to undertake a holistic evaluation. And they had substantial evidence of bad faith, which is the standard that this court set out in Wall Chapel South. There was dismissal of 20 obviously baseless cases where the Loman firm couldn't even find their clients, didn't know who they were. There were other issues with those cases. There was Loman's admission that he didn't know if Naviant was using an auto dialer. There was the perverse fact that the defendants advised borrowers to take steps to increase the number of calls that they allegedly didn't want. There were borrowers lying about wanting calls. They were filing lawsuits without clients knowing about it. There was the whole deceptive marketing practices of how they were recruiting borrowers into the scheme that was eventually shut down by the CPFB. There's the lack of a plan to deal with these claims. There's their knowledge that these arbitration proceedings jammed Naviant up. And there was the fact that Loman had testified that he hated Naviant. That's sufficient for the jury to have concluded that the barrage of claims that were filed, I see my time, Dr. Hunter, so, but this barrage of claims that was filed was not good faith litigation, it was sham. The district court could not have overturned that unless she found no evidence. In fact, there was lots of evidence meaning she had to have engaged in weighting of evidence, which is improper under Rule 50.
Well, she said it was sham, it was not sham litigation. After listening to being around this case for what was a couple of years, she concluded it's not sham litigation.
Correct, Your Honor, that is what,
That's what she wrote down,
that's what she wrote down, but to have done that, she had to weigh evidence,
which,
which is not the Rule 50 standard. The Rule 50 standard is if there's evidence that the jury could have weighed, taking all the inferences in our favor, in Naviant's favor, then you have to sustain the jury's verdict.
thank you very much, sir. And you save some time. Mr. Grell,
Yes, sir, thank you.
good to have you with us, Mr. Grell.
I'm glad to be here. And with me is Mr. Tom Urban, and Jeff Loman is also here in the gallery today. I want to address so many issues here. But first of all, this Norr Pennington issue is a real issue here that has always concerned me about this case. In fact, ever since this case, I make sure I get an express release whenever I settle anything. Because what Naviant did is they sued a lawyer for simply being a lawyer and for winning cases. Now, Your Honor, you were asking about their damage chart. It's on Joint Appendix 2603 and 2604. There were, let's see, if you do the math on this, their damages are based on 47 cases that were settled in favor of the Loman firm's clients. 47 cases. 5 were resolved by arbitrators in favor of the Loman clients, and 4 were resolved in favor of Naviant. I don't know how, and if you look at a fisherman's, the fisherman's case by this circuit, it says successful litigation is not sham litigation. How is that not successful? How is a lawyer who owes a duty to their clients to represent their clients supposed to stop suing Naviant when Naviant has paid 47 settlements? And when we asked Mr. Standish that question at trial, Mr. Standish said, well, you know, we just got to the point where we decided it was cheaper to settle these cases and then bring a RICO claim against Jeff Loman. And then we'd recover our damages on the backside. That is exactly what Norr Pennington is designed to protect. If you don't like the result in the first case, RICO, I don't care what other litigation theory you want to propose, malicious prosecution, doesn't give you a second bite at the apple. They didn't like the result. They didn't like the settlements that they entered into. They didn't like the arbitrators' awards against them. And so what do? They trump up a RICO claim that makes no sense, and then they sue Mr. Loman and a bunch of other lawyers in this firm for being successful, and they're calling it sham. That makes no sense on this planet. And if a lawyer can be sued for successfully settling cases, what are we doing? That's crazy.
Why did the judge let it go on for so long?
Well, and this goes to my question, to the issue that my colleague, Mr. Calhoun, brought up over and over again. There's substantial evidence to support the jury's verdict. He made that same claim on motions to dismiss, on motions for summary judgment. He made it throughout trial. When Judge Brinkema was asking him, where's your evidence, where's your evidence, where's your evidence? And she gave him every benefit of the doubt. Mr. Loman was required to produce even his attorney-client privilege documents, which is part of our cross-appeal. Still, no evidence of fraud. And she saw it at the end of trial. And if you go to her to the transcript, she awarded a directed verdict in favor of Mr. Loman's co-defendant, another attorney in this firm, Jeremy Branch. And at Joint Appendix 1732 through 33, or 34, Judge Brinkema says, look, I'm awarding a directed verdict to Mr. Branch because there's no evidence to support this claim. But what happens is if this goes up on appeal, she anticipated the jury would rule in favor of Mr. Loman. I don't want, and the Court of Appeals decides I did something wrong, I don't want this case to come back without a verdict. So, Mr. Loman, I'm sorry, but I'm going to let this case go to the jury against you. And if the jury doesn't make the right decision, I can always rule in the post-trial motions. Now, I'm paraphrasing what she said, but that's essentially the message she conveyed. And
And then she threw it out after the verdict
Yes.
came in. But you filed a cross appeal was that a protective appeal?
Yeah, yeah.
Okay. On a couple of issues, particularly on one about attorney-client privilege on discovery.
Right.
What, if we were to affirm Judge Brinkema, what happens to the cross appeal? Is it moot?
I think it's moot. Yeah, I mean, I think it's unfortunate, in our opinion, it's unfortunate that those clients were forced to give up their privilege. And Naviant correctly points out that some of the clients waived the privilege. My client at the time of this litigation had no problem producing those documents, but it wasn't his privilege to waive. And we explained this to Judge Brinkema and Magistrate Judge Buchanan. We have to fight this because it's our client's privilege, and we can't just
So
waive the
if
privilege.
That's what, if that's bad law, the ruling against you on the discovery, is that, say, in the book somewhere? I mean, even though
Yeah, it's there.
you would end up, if we affirm.
It's
this
out there on
case,
Westlaw, and,
if we- and dismiss that cross appeal as moot, that ruling is still in there somewhere.
and we believe it is still problematic, because when you look at her order on the privilege issue versus her final order on judgment, and you lay up the evidence of crime that she relied upon to waive the privilege, it's the same evidence that she relies upon to say there was no crime. And that's things like clients being told to record their phone calls. Well, anybody can record their phone calls, especially when Naviant, every time they get on the phone with the borrower, they say this call is recorded. If Naviant's recording the phone call, the recipient of the call can record it. Things, when he says manufacturing claims, it's that kind of thing. Recording phone calls, logging phone calls, revoking consent, which Mr. Standish, Naviant's corporate representative at trial, said point blank, absolutely, borrowers have the right to revoke consent under the TCPA to receive phone calls. All this pre-litigation conduct that my clients engaged in, it's just lawyers being lawyers. If this was a Fortune 500 company advising that company about their rights under a federal statute, we would never be here. But Mr. Loman represents normal people who don't understand their rights, and he told them, you consented by signing your loan agreement, but you can always revoke that consent. And the one thing that Mr. Loman could not manufacture that Naviant always glosses over is the phone calls. They made these phone calls. And when you ask whether this litigation was objectively baseless, absolutely not. We're not talking about 2 or 3 phone calls. We're talking about hundreds of phone calls. If you look at the arbitration awards that are part of the record, Joint Appendix 5681 through 5721, 233 calls, 226 calls, 235, 163, 127. Those are the victims who went to
Those are calls
arbitration.
to try to collect the loan, is that what they're called?
Yes. Their policy was to call a person.
What's the time frame, the spacing between the calls?
Well, that's unclear from the arbitration awards. It's the total amount of calls that these people received, but
Is there no periods of time?
you can do the math on it. Their policy, which Mr. Standish testified to during trial, is to call people 8 times a day. And if they don't get a pickup, the next day they'll call 8 times a day. If they do pick up on day 1, day 2, 8 times a day. So you can, basically, if you do the math, this is, I don't know, maybe a month, less than a month of phone calls. And this is, Naviant made these calls knowing that the definition of an ATDS was unclear. And this is also undisputed in the evidence.
Switching gears a little bit from whether it was sham or bad faith litigation or whatever. Is there evidence in the record? It seems like I've read stuff where some of the borrowers' testimony could be construed as the Loman firm bringing in action without their consent. And I'm trying to, we were jury verdicts, mean something. The standard is pretty high. And even if there was not a RICO claim or a tortious interference claim, kind of for the reasons you've already talked about, if there's evidence that the Loman firm brought lawsuits without authorization from clients, could that support a common law fraud claim?
No.
Why is that?
Well, first of all, when you say clients, plural, there was only one client that testified at trial. That's a gentleman named Brad Moore.
Okay.
No one else at trial testified. And when you read Naviant's brief, there are a lot of affirmative statements in there that have no cite to the joint appendix. And there are, I think, 1 or 2 times where he does cite the joint appendix to make that point,
Right.
and it's the testimony of Brad Moore.
Okay.
Brad Moore says, I didn't get a call before they filed my arbitration demand. He doesn't say they didn't authorize it. He says, I didn't get a call before they filed the arbitration demand. Now, the testimony at trial was that, and Mr. Loman testified at Joint Appendix 1278 through 1279, every client signed an engagement letter. Naviant never rebutted that testimony. The engagement letter is at Supplemental Appendix 184. That engagement letter authorizes Loman to litigate the claims. Every client signed that. There was no evidence to the contrary. There couldn't be any evidence to the contrary because they called no borrowers to testify at trial. And so Mr. Moore's testimony does not support that assertion. It just indicates that he didn't review the arbitration demand before it was filed. And those demands are 1 sentence long. It's not like a complaint, certainly not a Rule 9b complaint under RICO. And beyond that, ratification, as Judge Brinkema found, all of these clients received substantial benefit from this litigation. It was all paid to them. Mr. Loman simply took his attorney's fee out of it, which she said that he had a right to do because he conferred a benefit on these people. So they ratified it, and ratification goes back to the time of execution.
So that's what I wanted to get into. Assume there is some evidence, you may dispute it, I just want to play this out. Assume there's some evidence that there was initial demands, initial lawsuits without client approval. If the damages are the attorney's fees from the resolved cases, those clients would have permitted the settlements or agreed to them.
Yeah.
So that's the ratification point.
Right.
Even if there was evidence on the front end, and that
Yeah.
may be an issue, that may be good, bad, that's probably bad if it's true and maybe a violation of something, but from a claim for damages, if you ultimately agreed to the result of that, you'd say it's been ratified.
Right. And there wasn't, like I said, there wasn't a single client that came to trial to testify, Jeff Loman defrauded me. Jeff Loman stole my money. There was no testimony to that effect. And anyway,
But that's
Naviant,
not the claim. The claim is that Naviant says, you defrauded me by saying you represented, borrower A. You didn't represent borrower A. In response to that, I paid attorney's fees to bring a lawsuit based on a representation that you represented someone that you didn't. And, that maybe under the standard we look at, that part of a fraud claim might have some merit as I think about it. But I think your response is, even if that's true, the damages claims here all relate to settled cases or cases where someone got some benefit. And if there was some question, perhaps on the front end, it was ratified by the time they settled.
yes, and there's a ratification argument, and I will also point out that in every arbitration, 40-some briefs, and they're all in the appendix, Naviant argued this unclean hands defense, which is essentially the same argument that they make on the RICO claim. These claims are manufactured, clients didn't give approval, clients, were told to not pick up their phones, all of these claims that are supposedly the fraud from September of 2017, when the first brief was filed in the McLogan case, all the way through until even after we filed the complaint, they filed their complaint in April of 2019, they were still settling cases that Loman brought after they'd filed this litigation And in every case, they made this argument that the claims were manufactured and the claims were fraudulent. And in every case, that argument was rejected by the arbitrators. There is no support for it. And they're trying to, again, second bite at the apple. The arbitrators didn't agree with this, so maybe the courts will.
What, you talked at the very beginning about the Norr-Pennington doctrine and rules. Your colleague says that applies only once a lawsuit begins. Your argument seems to be that that's not right. That's what happens pre-litigation is what lawyers do, and that's not erroneous. Is your argument that Norr-Pennington applies to pre-litigation, or that for a different reason, pre-litigation conduct is not improper? Does my
Both
question
of
make
those arguments.
sense?
Yeah, both of those arguments. So there isn't, at least as recently, I've looked at this issue many times because it's always been, obviously this was arbitration, and a lot of the conduct they complain about was this pre-litigation conduct. One thing I want to be clear about is that Mr. Loman came in he has no relationship with GST, no relationship with these lead generating firms. Whatever happened over there had no concern to Mr. Loman. He just wanted people that were getting phone calls. And he very much disputes the fact that he told people not to pay their debts, because you don't get phone calls unless you're defaulting on your debt. He only wanted people that were getting phone calls. He's a TCPA lawyer.
I don't mean to cut you off, but I want your authority that Norr-Pennington applies to pre-suit stuff. So if you can say whatever, but you're over time, and I put you over time, but if you have an answer to that, I'd like it.
It's the Eurotech case, which is an Eastern District of Virginia case, and then the Sosa versus DirecTV case out of the Ninth Circuit, which talks about the breathing space of litigation. And arbitration is definitely within that breathing space. And if you look at Sosa, it was demand letters that were essentially set out by DirecTV that
There was
were.
one of these Norr-Pennington cases, I think Judge Floyd and I may have been on. Tell me again, you all are talking about the Norr-Pennington doctrine. What's your understanding of the Norr-Pennington doctrine? What is it? Tell me.
Well, that we have a First Amendment right.
We have a lot of cases up here. I mean, you all talking, sometimes you're talking in Greek. Go ahead.
Well, I have taught a class on Norr-Pennington since this case came out, but.
That's good. That's good.
I mean,
You cited that case that we were on.
what's that?
I said, I think there was a Norr-Pennington case that I was on with Judge Floyd
Watch Apple probably, or,
and somebody else, but I think the third judge wrote it. Go
yeah.
ahead.
Well,
I just wanted on the record here in this argument, what the Norr-Pennington doctrine is.
the Norr-Pennington doctrine essentially says that you can't be sued for exercising your First Amendment right to petition the court unless the lawsuit is a sham. And successful lawsuits are not sham lawsuits. So immediately exit.
I just wanted to get that out there. You both have talked about the doctrine, but nobody said what it is.
Yeah,
We have talked about sham litigation.
Right.
That's what was, and the judge let it go to the jury, and then she said there's no sham litigation.
Well, are the terms baseless and sham synonymous?
well, to be sham litigation, it has to be objectively baseless, and that's in the court's instruction to the jury. And here,
The jury came back with questions about what sham litigation was.
yes, and it has to be an abuse of the judicial process. And again, well, this damage chart that they submitted, that was their only evidence of sham litigation, a list of cases that were won and lost. And if you look at the one arbitration award that was part of the evidence that went in favor of Naviant, we put that into evidence, and that's the Daniel Lewis Arbitration Award, which is at JA 588, or 568-1. And that's the only arbitration award where there's any reasoned analysis of why the arbitrator ruled in their favor. The arbitrator says, this is part of the long history of evolving TCPA law. Here's Naviant's arguments. Here's Loman client's arguments. Both have authority to support their positions. I find Naviant's arguments more persuasive. He rules in favor of Naviant. No attorney's fees awarded, no costs awarded, nothing awarded. And there is no indication in this one opinion that's part of the record to indicate that this is sham litigation. The dismissals don't evidence sham litigation because They were voluntary. There were voluntary dismissals that were signed by Naviant. Naviant did not reserve any right to collect fees. Naviant, both parties bore their costs. The dismissals were without prejudice, so he can say those dismissals evidence something. They evidence that the parties walked away from the claims, which happens all the time. Was Loman supposed to keep litigating claims because the plaintiff dropped out? Or a lot of the claims, Sally Mae and Naviant, their relationship to the debtors changed, and Naviant was sued when it should have been Sally Mae, or vice versa. A lot of claims were dismissed on that basis. And of course, the settlements on this damage chart don't indicate sham litigation. There's zero evidence of
We
sham
kept you
litigation.
going a long time.
Okay, thank you, Your Honor.
But you've been asked questions, and Judge Baldwin may have another.
Okay, I'm sorry.
No,
I
no,
just
that's
got one
fine.
more question. I had asked your colleague to come back and show me the J evidence that there's damages sought by Naviant other than attorney's fees. It sounds like your position is that's incorrect. The only damages they sought were that chart you've just been referring to?
The chart includes settlements they paid.
Okay,
And
okay.
loans that were forgiven. So
Okay.
he put all of that
Okay.
into evidence. And then for cases where they were dismissed, or Naviant got a favorable ruling,
Yeah.
that's where their damages are limited to cost and attorney's fees.
Okay, I got you. So you would agree that settlement amounts, not just attorney's fees, are in evidence. You just would dispute that they're proper damages.
They're successful litigation. I mean, I don't know
got
how
you.
that's sham litigation when
I understand. Thank you.
we either won, well, they pulled out the cases we won before the case went to the jury, because obviously there's a huge causation issue there, and they didn't want the jury to have them. And then, so they pulled those 5 cases out. So the only cases that went to the jury were the cases they won, the cases that were dismissed, and the cases that were settled. But in the settled cases, that includes loans forgiven and cash payments made to the borrowers, in addition to attorney's fees and costs.
Thank you. You've saved a couple minutes, Mr.
Okay,
Terrell.
thank you.
But we have Mr. Charnoff on the list. You've got some time, sir. Good to have you with us.
Thank you. It's very good to be here. It's been a couple years. May it please the court. Good morning. Mike Charnoff on behalf of the GST appellees. GST is a company, GST Factory, Inc., and I represent 2 individuals. Greg Tremarsh, he's the T in GST, and Rick Graff, he's the G in GST. I only have a few minutes. I want to start by pointing out that on August 20th of 2021, the Fourth Circuit issued an opinion called Sardis. It's in the brief, Sardis versus Overhead Door Corp. And it's essentially affirmed and discussed the Rule 50 standard and discussed why we have it and how we apply it, and that the moving party is entitled to assert those same arguments here on appeal. That happened to be the very same day that our district court allowed a completely baseless case to even go to verdict. And there's been some colloquy about, why did it go as long as it did? And I want to briefly echo that there's repeated references in the record that I'm going to let this play out. And this court, I thought the court was going to dismiss it at the close of the plaintiff's case. And then I thought they were going to dismiss it at the close of the defense case. And then we renewed it. And so I think there was shock or surprise that the jury did what it did. But that's important. It goes to the Rule 50 standard, because the task here is to determine whether there was a legally sufficient evidentiary basis for a reasonable jury to render the verdict that it did. And so while the ultimate ruling is a relatively brief and straightforward, narrow, dispositive ruling that wipes out all the claims, I don't want this court to lose sight of the fact that there's more than half a dozen dispositive arguments all over the record that we argued repeatedly to the trial court. And that
But they were rejected.
they were not rejected.
Well,
They-
you either won, your motions were denied. I hear you saying the district court was essentially saying, I agree with you, but I'm going to let this play out. But the net effect of that is to deny the motions.
That's correct, but this court always has the ability to affirm on any basis fairly supported by the record. And so let me start with one issue which I think is the lowest hanging fruit, just as it's so illustrative, on the tortious interference with contract count. The jury found in favor of a defense verdict of both of my individuals, the G, Rick Graff, and the T, Gregory Tremarsh. They were found to be without liability. And yet, they found liability against GST on the tortious interference count, even though there's no agents to do it. And one of the jury questions, we discussed one jury question, one of them was they asked, how do we distinguish between individuals and entities? And Judge Brinkman gave them a very succinct and correct statement of Virginia law that entities only can act through their agents and employees. And if Rick Graff wasn't tortiously interfering with the contract, and if Gregory Tremarsh wasn't, and there was no testimony about the S's, a guy named Buddy, I think it's Severs, who didn't testify at trial, hardly mentioned at all, if there's no agents who could be tortiously interfering with the contract, how on earth can you exonerate the individuals and then find the company did it? There was zero testimony, none, about any employee. So it is an utterly senseless and completely unsupported. And I only use that as it's just an easy example, but the record is just replete with it. I know I've only got a couple of minutes, but just going into the count two RICO, there was uncontradicted evidence that there was no association, in fact, enterprise, and that my clients did not conduct the enterprise through a pattern of racketeering activity. Both Mr. Tremarsh and Mr. Graff testified that their purpose, their sole purpose, was to give private student loan debtors affordable access to attorneys who can assist them. That was it. That was the only testimony as to their purpose. No one else testified about that, and all of this came in through Naviant's case. Conversely, the GST appellees had no point or purpose to file TCPA claims. The undisputed testimony was that GST is not a law firm. Mr. Graff is not a lawyer. Mr. Tremarsh is not a debt relief attorney. The GST appellees never filed a TCPA claim. They never suggested anyone do so. The only testimony was that they didn't even know what the TCPA statute was. They never told attorney David Mize about the TCPA, and he testified the same way. No contrary evidence. Again, zeros. That's the standard in Rule 50. There has to be some evidence, legally sufficient evidence, a reasonable jury could credit. It doesn't exist here. GST didn't have the purpose to defraud Naviant. The only testimony was that GST and these two principals didn't even know that Naviant existed or who Naviant was until the very end of the timeline. How could they possibly have a purpose to defraud them? Mr. Tremarsh's testimony was that the GST appellees never counseled, I'm sorry, my time is over. May I finish my thought?
You finish.
Thank you. Mr. Tremarsh's testimony was that the GST appellees never counseled borrowers to stop paying loans. They had no communications with the borrowers at all. And the uncontradicted testimony was that there was no relationship between the Loman appellees and the GST appellees. Never a phone call, never an email, text message. There was zero communication between these two different groups of appellees. And that's all of the testimony in the form of testimony from the stand, interrogatory answers, all of which Naviant introduced into the record and had nothing to rebut it. That was uncontradicted testimony that Naviant put into the record. And so it was literally impossible for any reasonable jury to have any legally or any basis to have made any of these findings. And so I understand that the court's ruling was a narrow one, and I think it's completely effective and dispositive, but I just want the court to keep in mind that you can affirm on any number of bases. And the tortious interference claim, I just use that as an easy example, is completely unfounded. And, and frankly, this is why we have Rule 50, because sometimes even the best meaning and well-intentioned jury can be led astray. And this is why we have Rule 50 to prevent those sort of abuses. Is there any questions for me?
Thank you very much, sir.
Thank you.
Good to have you with us. Thank you. Mr. Calhoun?
Thank you, Your Honors. George Calhoun for Naviant. Several things I want to address in response to that. First, it's a little bit telling that they think the jury got everything wrong. It's not a narrow issue that they're complaining about. They think the jury got everything wrong, and that's just not the case. I want to address briefly the crime fraud issue that my colleague raised. That ruling was completely vindicated by the RICO judgment of the jury. It's notable that the decision overturning this case made no decision whatsoever about the underlying merits of what happened. It's a causation ruling. In other words, if we presented our damages differently, there wouldn't even been an issue. So the findings of the RICO conduct, not even challenged on appeal, right? There is no appeal that the RICO predicates weren't proven. So that's pretty telling. The crime fraud issue is bulletproof in my view. None of my opponents have really addressed the standard that we're dealing with here, whether there's any evidence to support the jury's verdict. They've made wholesale arguments as if this were the district court once again. Because they haven't disputed really any of the evidence we put in, they haven't met their burden of proving that there's evidence, that there's no evidence that supports the ruling. On this issue about connectedness with GST, I'll rely on the language of one of the settled defendants, who in describing this enterprise, mind you, he described it as an enterprise. This isn't our language. One of the more remarkable smoking guns you might see in a case. Scott Frieda, who was one of the defendants, was complaining in an email to the defendant David Mize, and he noted how GST had built out the enterprise and Mize had helped to build out the additional layers being the Loman defendants, who were brought in because the scheme was having cancellation problems. They were bringing in all these borrowers, taking their money, having them stop paying their lenders, and the borrowers were figuring out that nothing was being done and they were canceling. So they brought in the Loman defendants as an effort to reduce the cancellations by bringing these lawsuits. I wanted to address the question you'd asked my opponent about Nora Pennington. It originally started as an antitrust concept, Your Honor.
I remember some of that, but you guys throw this language around terms that sometimes that need to be read on the record.
Yeah, it can see how it would be confusing. I will note,
Sometimes they put them in English.
I disagree with the statement that anything pre-litigation can give rise to Norm Pennington.
So you differ with his definition?
I do.
Well, that's good.
And I think that the critical point here is that a lot of the conduct here, remember, we have a RICO conspiracy here found by the jury, and a lot of the conduct involved creating the conditions where they could bring a lawsuit. It wasn't just a client came to them and they said, I'm going to bring a lawsuit. If they had just filed a demand letter, if someone called them, said, hey, I'm getting these calls, I don't like them, let's send a demand letter, we might have a different case. But they were running people through this pipeline to try to create the conditions where they could even possibly send such a demand letter by having them default on their loans when they weren't their clients at that point in time. And I'll also note the Fourth Circuit hasn't ruled on this, but courts in the Eastern District of Virginia have concluded that Norm Pennington doesn't even apply to private arbitration because that's not a petitioning the government. That's a private dispute. Only 5 of these cases were filed in court. The rest were private arbitrations. That's the Ford Motor Co. versus National Indemnity Company from the Eastern District of Virginia in 2013, 972 F sub 2nd 862. So to the extent that and the district court didn't rule on Norm Pennington, but to the extent that you're considering that, it really applies to a small subset of the claims here. It's not dispositive, and there's substantial basis to support the jury's damages verdict, regardless of whether you kick out a few here or a few there on any basis. And almost all of their arguments are going to nibbling around the edges. The core of the jury's verdict is eminently supportable, and that's the point that's important here. Their argument that we didn't present any evidence about the damages on this point is also not true. Mr. Standish, who is an executive at Naviant, testified at length about how the lack of the non-payment when these borrowers defaulted, how it impacted Naviant's bottom line. There was significant testimony on that. It's cited in our briefs. They have 2 cross appeals. I'll just mention them briefly. I don't know if you're on. One, they complain about expert issues that the court admitted, testimony from experts on reasonableness of attorney's fees. As to their expert that we called, they've admitted that that testimony was not helpful to Navient. That means it's harmless error. You don't need to consider it under any circumstance. As to Navient's expert, they cite this Virginia cases for the prospect that there's a rule requiring expert testimony to support the reasonableness of attorney's fees. The cases they cite all reach the opposite conclusion, that expert testimony was not required, In any event, there's no federal rule, and Navient had attempted to call this expert in their own case in chief. It was the district court's decision to hold that. So my time is up, Your Honor. Something.
Thank you very much, Mr. Calhoun.
Thank you.
Mr. Grill?
The confusing part is in this whole fact pattern is you have to look at where Loman comes in. Loman's only connection to the enterprise is through Mize, Slaughter, and Johansson. These are the three lawyers that were hired by GST to try to help these student debtors. And it's interesting that Naviant says, oh, these guys is all a sham. They weren't trying to help anybody. They were just trying to make. These lawyers were brought in, and they were trying to figure out ways to help these students. And it just so happened that Jeff Loman had a conversation with David Mize, and Jeff's a TCPA lawyer, and he said, well, are they getting phone calls? And Mize said, yeah, from Naviant. And Loman's like, oh, well, Naviant never abides by the TCPA. We'll just start interviewing them and advising them to revoke their consent and to log their phone calls, and that's $500 a phone call. And once we reach a level that makes economic sense, we'll file a lawsuit. That was where Loman came in. Loman had no contact with anybody but the three lawyers that were referring Naviant calls to him. He had no contact with anybody at GST, none. And in any event, when he says that Naviant was injured because students were advised not to pay their debts, Naviant does not own these loans. They're owned by trusts, and Mr. Standish testified to that. Naviant is only a loan servicing company, and they were obligated to reimburse those trusts when they screwed up, and they screwed up in this case. And for that reason, they ended up paying cash settlements to Loman's clients and forgiving debt. It was their decision to forgive the debt, not Loman's. He would have been happy to take a cash settlement. They wanted to write off the debt because it was better for their bookkeeping. But there was no damage to Naviant because loans weren't paid. That was all to the trusts. And to the extent there is some residual benefit that Naviant gets, under the Galbraith case, residual beneficiaries don't have standing under RICO. And to go to this last point about damages, obviously the successful litigation, the cases that were decided in Loman's favor, how can they claim that as damages? They either decided to do that or they lost a fair fight. And when you get down to the dismissals and the cases that they won, this question on our cross appeal is critical. They presented no expert testimony to establish the reasonableness of their fees in any jurisdiction, nor their costs. They tried to call our expert witness in their case in chief, which the judge allowed them to do. Our expert said their fees aren't reasonable, at least as far as Virginia and Maryland is concerned, where I'm authorized to practice. And I'm sorry, my time is over, but no expert
I think
witnesses.
we understand your position.
Got it. Thank you so much.
Thanks very much. We'll come down and greet counsel and then take a short break.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated. Our third case is Open Justice Baltimore et al. Versus the Baltimore City Law Department et al. And we have Professor Sofstrom.
Apologies, Your Honor, if I was premature in standing up. My name is Jennifer Safstrom. I teach the First Amendment Clinic at Vanderbilt Law School, and it's my honor today to present two students who will deliver argument for plaintiffs' appellants. And I wanted to introduce both Mr. Jacob Robbins, who will deliver the affirmative argument, and Ms. Chelsea Summers, who will deliver rebuttal. And I will also note this honor exceeds only my own in having first delivered oral argument before this court many years ago, and so I'm excited to extend the same privilege to the next group following behind us.
It's good to have you come back. You're the professor. who
Yes.
Teaches the,
Yes, I am.
their class. What do you call it? The clinic?
It's the First Amendment Clinic.
First Amendment Clinic. Well, we really appreciate you all being with us and helping us out with this. And Mr. Robbins? And you're a third-year student?
Yes, Your Honor.
Good to have you here.
It's good to be here, Your Honor. Thank you. Good morning, and may it please the court. My name is Jake Robbins on behalf of the appellants, and I am joined by my co-counsel, Chelsea Summers. The issues in this case concern the First Amendment's protection of those who seek public records without fear of retaliation or discrimination from the government for their speech, and specifically the proper standard to review such issues at the motion to dismiss stage. The motion to dismiss standard requires that the court assume the facts from the vantage point of the plaintiffs and draw all reasonable inferences in their favor. Our clients sought to bring transparency to their local government by publishing materials that shed light on the Baltimore Police Department's practices. Because they exercised their First Amendment right to publish these materials, their local government repeatedly delayed responses, narrowed requests, and charged exorbitant fees to review files under the Maryland Public Information Act. These facts, if taken as true as must be done at this stage, cognize a First Amendment claim for the following three reasons. First, plaintiffs pled a plausible retaliation claim as our clients previously aired criticism of defendants, so it is plausible that defendants delayed and obstructed requests because of previous criticism rather than making simple determinations under the MPIA. Second, plaintiffs pled a plausible viewpoint and content discrimination claim as our clients previously criticized police conduct, so it is plausible that defendants selectively delayed and denied requests because of their viewpoint and the content of misconduct-related files. And third, plaintiffs pled a plausible municipal liability claim as they can establish a practice so persistent and widespread as to constitute custom with force of law, that custom being obstruction of production, or other theories of municipal liability in the alternative. I would like to begin with the retaliation argument.
So could I ask a question before you get into that, just so I kind of, at least in my own mind, get my bearings straight? Your client, and you just mentioned this, has criticized the Baltimore Police Department and city, and you know, a lot of your argument is that that creates a plausible basis for the conduct that you challenge. In thinking about this, it seems like, you know, it's not uncommon, maybe even it is common, that a lot of people or entities that request records may have a political affiliation, and but yet the Act provides have provisions where a municipality can object or limit what gets produced or redact or seek fees and all that information. So it seems like there must be more must be required than knowledge of an entity's political views, even critical political views, and exercising statutory rights. And then kind of weeding through your arguments, it seems, and the court's decision, it seems like those might be, the what else is, required might be some direct evidence of, disfavor of content. It might be comparisons with other entities, and it might be just actions that are so frivolous that on their face there must be some other explanation. And the court seemed to address those issues, and I know you disagree with them, but just from a framework, is that an accurate way of looking at what must be proved? Is there something else there that I'm missing? Does that help?
Yes, Your Honor. I would only, I guess, specify further what you just laid out in that what the further evidence that you referenced, what is more is borne out under the retaliation and the viewpoint and content discrimination claims under their various requirements. You mentioned comparators, which I'd be happy to get into under the viewpoint claim, and also the causation element of the retaliation claim. With evidence here, with temporal proximity as an indicator of retaliation, we can see in that one of the forms of protected speech in this case is lawsuits filed by Open Justice Baltimore. And in one instance, Open Justice Baltimore had requested that Detective Diesel's file be provided to them at no cost. And then suit was filed in June 2022, and less than 3 months later, the police department then imposed a $7,000 fee for production. So that's one indication beyond, and that further substantiates the retaliation at hand. But there's other indicia for the other plaintiffs as well. Mr. Soderberg had published a book specifically on the police department's gun task force, and he is a regular journalist on issues of police misconduct in the Baltimore community. And he had sought these misconduct-related records that are directly, they directly correlate with the type of materials he's published, like that book, that indicate further that they are retaliating against a particular viewpoint that is speech that is critical of police misconduct practices. I'd also raise that the district court, as you mentioned their opinion briefly, made a factual determination that these allegations suggest bureaucratic dysfunction instead of retaliatory motive, and imposed a heightened causation standard under the previously discussed prong that is designed for summary judgment, and in that sense erred. In Toby, this court did not wade into the question of whether defendants' actions were, in that case, reasonable, in that the arrest was made because of plaintiff's outlandish behavior in that case, or because of protected speech. Here, the district court erred by drawing such a determination in ascribing defendants' conduct to bureaucratic dysfunction instead of retaliation. Also in Toby, the court noted that defendants in that case erred by citing the more rigorous causation of a requirement that applies at summary judgment. And the district court, in this opinion, cited Raub v. Campbell of this court, which is a summary judgment case laying out that heightened requirement. That application is also error. To move to the viewpoint and content claim, briefly, Your Honor, we just discussed the third prong in the district court's error, but I'd just briefly, moving backwards, like to raise the second prong of retaliation and note that defendants' retaliatory action did adversely affect plaintiff's speech in that it hindered their ability to criticize the police department. The standard for this is an objective inquiry asking whether the action taken would chill a person of ordinary firmness from exercising their rights, per ACLU of Wacomico County and Snoy and Boss v. Curtis, both of this court. It is not a question into plaintiff's actual response, per Martin v. Duffy of this court. And applying that here, plaintiffs previously aired criticism of defendants' practices, as we've discussed. And then defendants obstructed production of record requests, and in some sense you can imagine it as really a stick to bring critical voices into alignment, because as investigative journalists and a nonprofit that maintains a website detailing police mispractices and other sorts of investigative journalism, they need to substantiate their publications with things akin, and in this instance, they need the police misconduct files themselves. So when they obstruct the production, it leads the person of ordinary firmness to self-censor themselves so that they can continue to access.
How do we know that? Is that just we assess that kind of ourselves? I mean, it sounds like you don't contend your client was deterred at all, but that's not the test. The test is a person of ordinary firmness, whether they would be deterred from filing lawsuits or making complaints or whatever. Do we just kind of, is there any standard by which we go to, or, I mean, can you say that an ordinary person of a person of ordinary firmness would be deterred, Are we supposed to just accept that as true just because you say that?
I think at the motion to dismiss stage, Your Honor, drawing all reasonable inferences in plaintiff's favor, that conclusion can be drawn, and perhaps
So you just
through-
making a conclusory allegation that a person of ordinary firmness would be deterred, we're supposed to accept that?
I think that when you look at the nature of their publications and how dependent they are for these sorts of materials to create, you could imagine an investigative journalist trying to publish something without these sorts of materials, and I just think it wouldn't be properly characterized as investigative journalism at that point. And so I think when you look at the nature of what they've previously published, it is not conclusory to find that it meets the standard at motion to dismiss, granting all reasonable inferences in plaintiff's favor. Moving to the viewpoint and content discrimination claim, Your Honor.
Now, you took retaliation first.
Yes.
That would indicate to me, I think, that you think that's your best claim.
Well, Your Honor, I think we have strong.
It's count 3 is where it's specifically denominated.
I
I
think-
misconstrued it?
I'm sorry, I think that.
Did I misconstrue in saying that retaliation must be your best claim, that you think?
I think that all our claims are equally,
they're all good.
equally strong, Your Honor, yes. And just moving to.
But you had to get flipped then. You didn't do it in order. You went after the count 3 first.
I thought maybe it would help frame the rest of the discussion, just the way that the test is laid out, and retaliation might be helpful, but I think they're equally strong. Under viewpoint and content claim, we would begin by noting that a valid First Amendment claim can derive from the government's denial of records. Under Sorrell v. IMS Health of the Supreme Court and Fusaro v. Kogan of this court, in the Fourth Circuit, it's held that placing suspect conditions on accessing government information can present a valid First Amendment challenge. Here, defendants did so with police misconduct records. And under both the viewpoint and content discrimination claims, those were the vehicles and the medium by which they engaged in the discrimination. Under the viewpoint claim, there's notice of plaintiff's views, as we previously discussed, Mr. Soderberg's status as a journalist on these issues, but also Ms. Figueroa is a very similar journalist in this community, regularly reporting on this material, and she identified herself as such in her request for records. Open Justice Baltimore maintains the previously discussed website, and Ms. Walden of the Law Department, one of the defendants, has explicitly asked that they take down information from that website. With this notice in mind, and applying the motion to dismiss standard under this court's standard in International Association of Machinists v. Haley, the defendants must show an obvious alternative explanation for each alleged actions.
Is the information that was asked to be removed the names of, the specific names of people?
I believe that's correct, Your Honor. I would have to, we can on rebuttal
But that's,
confirm.
the request to take down information wasn't substantive information, it was identifying information about individuals.
I can't answer that with absolute certainty right now. I think that is among the information, but we're using that just to establish notice of the website itself, that takedown request. We would note comparator evidence exists here and begin with the fact that across 580 requests and data revealed by the police department itself, defendants took 8 times as long to respond to media requests compared to state's attorneys and law enforcement. And as to Open Justice Baltimore, comparing Michael Fortini, who is an associate at a private law firm with no history of criticizing the department, he was given a file on 2 officers within 6 months, whereas Open Justice Baltimore was given only a partial version of a file in nearly 9 months.
But the district court says, well, that's not really a fair comparator. You have 18 requests, they're very broad. Maybe within it, you can pick out something that's narrow, and that might, maybe coincide a little bit with the comparator you talk about. But you've essentially compared apples and oranges, and that's not how comparator evidence works, even at a motion to dismiss stage. What's your response to that?
We would respond that request, that comparator evidence that you just addressed is one of multiple, and we would revert and emphasize again the data and also comparator evidence for Mr. Soderberg and Ms. Figueroa, that all together at the motion to dismiss stage.
But the data doesn't go request by request, right? I mean, in this case, again, the district court says you got all these requests that are so broad. Are we able to look then at kind of conclusory data that doesn't parse it out and say that you made a plausible comparison?
We believe with all reasonable inferences drawn in our favor that that can be done, but we'd also briefly mention, comparator evidence aside, that there's other evidence indicative of discrimination here. For example, a fee waiver was previously to be granted to cover what was then discovered, a production that was reduced in scope upon investigation into the scope of production. And when that fee waiver was found to cover full cost, defendants refused to honor it when they realized plaintiffs would get that production for free. So comparators aside, we believe that the additional evidence substantiates the claim. With the time remaining.
What request was that, or was that, can you just tell me?
Yes.
Was that to a particular officer, or can you just tell me what that was about real quick? I know you got limited time.
Yes, Your Honor. That Open Justice Baltimore requested officer misconduct complaints from 2020 to 2021.
Right.
This, more detail on this is observable at the complaint, Joint Appendix page 19, and as well as Joint Appendix page 81 to 89.
Okay.
If I could just go to the municipal liability argument with my time remaining, I would note that Monell liability can be established against municipal defendants here, the police department and the city, and that there is no heightened pleading standard for Monell liability, which the district court correctly stated at Joint Appendix 685. This court has affirmed this in Owens v. Baltimore City State's Attorney's Office in saying that the recitation of facts to support such a claim need not be particularly detailed, nor the chance of success be particularly high. Applying that here, plaintiffs have alleged a condonation theory for Monell liability in that there is a widespread practice that constitutes a custom with force of law, being the obstruction of production. This length of custom is long. It dates back to 2019, which is pre-COVID and pre-Anton's law. You can see in the record the sort of obstruction engaged before those events unfolded. And then just briefly to note that policymakers can be found to have actual or constructive knowledge and deliberate indifference in this custom via the extent of communication between employees and plaintiffs. I know I'm over time. If I could just briefly finish this thought. The appendix.
Go ahead.
Thank you, Your Honor. The appendix is chock full of communications revealing these obstructions by both the police department and the city. So to the extent that constructive knowledge and deliberate indifference at the motion to dismiss stage is shown by employee misconduct, plaintiffs have exceeded, I believe, the standard at this stage. Thank you for your time.
Thank you very much for your work. We really appreciate it. Mr. Fox?
Your Honor.
Good to have you with us, sir.
May it please the court, Gregory Fox, Baltimore City Law Department, along with my colleague Michael Redman, on behalf of the appellees. The court has three avenues here in which they can affirm the district court's decision to dismiss the First Amendment claims. The first avenue is that the government cannot violate the Constitution by allowing access to only certain records. The second avenue that the court may go down to affirm the decision is that the government, or the appellants, did not adequately plead, that the government either discriminated against them or retaliated against them in responding to their PIA requests. And then the third avenue is that the appellants have not adequately pled that a government policy caused their constitutional harm.
Is the first ground you made part of the district court's reasoning?
No, Your Honor. The district court...
Why do you ask us to do something as your first ground for affirming something the district court didn't do?
Just that there is adequate evidence in the record for the
Why
court
don't you
to...
tell us why we would affirm the district judge on what she did? She did 12b-6.
Yes, both would be a failure to state a claim, would be an adequate basis to dismiss the case on a failure to state a claim.
Are you abandoning the district judge?
No, that's just an...
You're saying she's second best, that she's got a better way to do it? Did you present that to her and she ignored it?
Yes, all these arguments were presented to the district court judge.
But you think she decided it on the wrong ground?
No, just that she chose the second avenue to dismiss the case.
She's decided on what you prefer, so you start out with that. Had that happen.
Sure. Again, there are three different avenues, all of which can result in a 12b-6 dismissal of the case.
Well, usually the lawyers come in and say that the district judge got it right.
The district court did
When they win, what you did.
Yes, again, the district court got it right. They chose avenue number 2 and dismissed the case on that basis. There are 3 separate ways that could be done in this case.
Do it however you want. Go ahead. I'm sorry.
Happy with either of the 3.
I won't charge you with that time while I'm here.
Well, with respect to the first avenue that the court can go down, to plead a constitutional claim under Section 1983, obviously the first thing that has to be pled is a violation of a constitutional right. And what the appellants have alleged here is that the alleged constitutional harm is a denial of access to police misconduct records. And that kind of gives us to the fundamental issue in this case, is that the appellants have a constitutional right to speak and publish without any government interference. They don't have the constitutional right to access certain records. So their claim here that the government has stymied all access to police misconduct records, while could be a violation under the Public Information Act, would not be a violation under the First Amendment. And that is borne out in the case Hawkins versus KQED Inc., the Supreme Court case, that essentially says that there is no constitutional right to access government information. And the court specifically says the Constitution is not a Freedom of Information Act. There's another case out of the D.C. Circuit. It is the Center for National Security Studies versus the DOJ, in which an activist group filed for a FOIA violation under the First Amendment and violations of FOIA. The D.C. Circuit discussed the interplay of the First Amendment and FOIA, and they specifically say the First Amendment protects the right to speak. It does not address the right to receive information. So again, the government here is accused of violating the Constitution by saying we're not going to give anyone access to these records that portray the police department in a poor light. Again, could be a violation of the public information if everything.
So does that argument kind of get to the, we have these cases like Baltimore Sun and some others that talk about if what is alleged to be a First Amendment violation is actually seeking some discretionary information or right or something like that, that, you know, that doesn't, you know, amount to a First Amendment claim?
I think that's correct, Your Honor. And what you see here is that this lawsuit is an attempt to enforce the Maryland Public Information Act.
But does that mean, I mean, let's assume there was direct evidence that, you know, they produced, that there was a smoking gun that they got that said, we're not going to give these folks information because they criticize us, and we're just not going to do that.
Mm-hmm.
So direct evidence that you're not producing because of their viewpoint or what they've done. You're saying that's not constitutionally problematic?
So there is, and just what has been alleged here is that the government has at large said we're not giving anyone
Yeah, but
police
you're just,
misconduct.
I'm trying to follow what you're
Sure.
saying, because you're saying there's no constitutional right to access to information. And if that's true, then they could do what I just said, and would your argument still be that that's not unconstitutional?
So the court would have to carve out another exception to the Hawkins case, pointing you to Fisara versus Kogan, which is a Fourth Circuit case that carved out one narrow exception to the broad rule is that there's no constitutional right to access information. In that case, a Virginia resident was seeking Maryland records, specifically voter information records, so he could go out and kind of canvass and criticize the office of the state prosecutor. And the Fourth Circuit in that case said, what he's challenging here is not the right to access information, but the conditions on the access here, because the Maryland law said only some people can get this information, whereas people who are outside the state of Maryland can't do that. And because these records are so important as a vehicle for speech, that's going to be subject to First Amendment scrutiny. You don't have that here for two reasons. One, because there's no allegation that anyone else with a different viewpoint has received these records for free within 30 days or received them at all. And number two is that these records are not the same vehicle for political speech. Again, the voter rolls were the means by which you could get an address, a phone number, and actually contact people to do your campaigning. Here, no one wanted to talk about those records. They didn't want to publish information about the voter rolls. It was the vehicle to contain or to maintain speech.
So that you let me just follow up and make sure I understand your view on this first vehicle, and maybe this is why we're kind of wondering why you're going down that route, but that's your argument. So that case about the voter rolls is an exception, as I recall, to this general rule that you're not entitled to information. And so you would say, I think, back to my question, under Fourth Circuit law, no right to access, there's a limited exception in the case you just described. Absent another limitation in the hypo I proposed, no constitutional violation?
Correct, and the court would have to make another exception to the general rule that there's no right to access information. But getting to the actual district court's opinion here, going through each of the cases, and what you have before the court, even on the motion to dismiss, is every conversation with the government between the requesters and the government in the case. And there is no factual support for the allegation that the government considered the content of the records before responding to the request, the viewpoint of the requester before responding to the request, or retaliated against any of the requesters in any way. And so what the appellants have done is essentially said, because of who we are and the types of records that we're requesting, that any violation of the Maryland Public Information Act has to be because of those bases, but didn't support their conclusion with any facts that they
So
pled.
do you, at the beginning of your colleague's argument, I kind of laid out how I was trying to think about these claims, that if you have a Freedom of Information Act sort of statutory structure that gives the defendant or the public entity the right to object and redact and seek fees, et cetera, and the requester has a political affiliation that's known, that the denial of the request or the utilization of some of those statutory rights or responsibilities can't on its own be a First Amendment violation. There must be more.
Correct.
And what I suggested that could be more are actual direct evidence of viewpoint discrimination, although you kind of, I think, that's number one. Number two, different treatment of similar type of request. Or three, just, almost bad faith, utilization of the statutory rights. Does that framework, you agree with that framework subject to your first argument?
Yes.
Okay.
And what you have here, if you look at all of the requests, and in the briefs kind of group them into three separate categories, but the categories that haven't been fulfilled, they all involve a dispute under the MPIA's fee waiver statute. And that case is actually pending before the Maryland courts, as the government here would argue, as it should be. So the government here was just exercising its authority under the statute to charge for records when these massive requests come in. When some of these requests were for 3,000 investigatory files. The government was exercising its discretion or the right it has under the statute to impose fees, and then there's a dispute over whether or not those fees should be waived. But that was sort of a roundabout way to answer the question. Yes, I believe that's a proper framework, and the comparators here, as you sort of alluded to earlier, aren't direct comparators. There's no allegation here that any other requester with a different viewpoint from the appellants received the same records they were requesting for free or for within the statutory limit of 30 days. And in fact, the comparator evidence seems to suggest that the government is producing records to people that criticize the Baltimore Police Department all the time. The district court highlighted requests from the Washington Post, from the Office of the Public Defender, from the Maryland Daily Record, specifically from Justin Fenton, a reporter with the Baltimore Banner, who has written books about the Baltimore Police Department, all receiving their record requests that were different from the records that the appellants have requested here. But there is no one-to-one comparison.
Can you help me with the issue you just raised, that the Maryland court is looking at this issue of fee acceptance or rejection? What do we do with that? I mean, the district court, as I recall, relied on that in the first order and said, to the extent we have that issue, I'm dismissing that claim. Is that right? And are you that would be almost like a, abstention sort of thing. Or is that, but I don't remember really anyone framing arguments in abstention, language.
Correct, and what the district court did, because this case involves 18 records requests, 6 of those records requests were already part of state law lawsuits.
Okay.
And the district court said, well, you've split your claims here, you can't sue in state court, have these be pending.
All right,
and
these
then
are
also-
ones that aren't in state law that we're
Correct.
talking about now.
But the main issue of the fees would all resolve all of the dispute here.
Well, but then you should be arguing abstention, right? You should say, we shouldn't be doing this because it's intertwined with a state court ruling and we should defer, and are you arguing that?
That was argued before the district court, that was in our motion to dismiss
Right.
brief, but the way that the district court made their ruling, we didn't brief it here.
Yeah, so that, you didn't present an abstention argument on appeal.
Correct, no, Your Honor.
Okay.
And getting to the.
Could you have, under your other theory, if we could affirm on some alternative basis, you brought out an alternative basis right out of the box here. Did you, is that, would that abstention argument be another alternative theory for you?
I think it would be, Your Honor.
But you abandoned it,
Yeah.
right? I mean, the other one you argued on in your briefs, this one you abandoned, so we can do it. We can overlook your abandoning it, but we'd have to, go a further step to answer Judge King's question than the first point, right?
Correct, and we did put information in our
So
footnote that we.
you didn't, at that point, think much of the abstention. You went to that other theory.
Correct,
That was
and we.
different than the one Judge Hollander wanted to rely on.
Correct, and what we did was just addressing the arguments that were made in the appellant's opening brief. But I did want to talk about 2 of the requests, which seem to be the main driver for many of these claims. They are the request for the James Diesel file, which we call in our papers request number 8. We numbered them 1 through 18.
Request
And-
number what?
Number 8. And then request number 7, which is the one discussed about the revocation of the fee waiver. First, to discuss about request number 7, that does fall under the claim splitting issue that the district court raised. That is part of a state law lawsuit where the appellants have already filed under the First Amendment, and the Circuit Court for Baltimore City dismissed that case, or dismissed the First Amendment claims. But more importantly, if you look through the factual record, it's not a revocation of the fees. What happened with this request and with all the requests where there's a dispute over a fee waiver, the government would receive a broad request for records. They would suggest a narrower scope to perhaps fulfill the request, and they would offer these summaries for free. If a requester said, okay, well, we want the full files, we don't want these summary information, the government would then produce a cost letter saying, here's how much it's going to cost to review and produce all of those records that you're requesting. Because of the scope of the request and the burden on the government, we're going to have to send part of it out to, or send part of the assignment out to a vendor. And that would be what the cost letter would look like. And then the government would, in these cases, before the appellants, when a fee waiver was made, the government would waive what they called the internal cost, all the cost to the city and the Baltimore Police Department, and still impose the cost of the vendor to the appellants. And it was that decision.
Pass that through.
Correct, and the requester would have to pay for the vendor cost. So that decision, when request number 7 came in, that was the decision that the government made. They said, we're going to waive our internal cost and we're going to impose the vendor cost. Through the course of the litigation, it turned out that there were actually probably fewer records that were responsive to the request. So the government said, okay, well, instead of 3,000 records, it's about 2,000 that are probably responsive. We're going to do the same thing. We're going to waive our internal costs and we're going to impose our external fee. But because the waiver in the first part exceeded the total cost in the second, the appellants have characterized that as a revocation of the fee waiver. But that's not what happened if you look through the record.
This is, your argument, and I read about this, is that, this is kind of factual. I mean, it's kind of like parsing out, and you may be 1,000% right, but how do we do that at a 12B6? They're saying something, you're saying something. Is that, is that plain from either the complaint or the exhibits to the complaint?
Yes, Your Honor, it's plain from the exhibits.
So they attached exhibits that essentially untangle it the way you just
Yes.
described?
They conclude that it's a
So
retaliatory
that's
action.
all part of the complaint. part of
Correct,
it.
Your Honor. There's 44 exhibits to the amended
And
complaint.
it's appropriate to be considered in a 12B6.
That's correct.
And that, and I'm sorry, District Attorney.
No,
And that was part of the district court's analysis in the second order, as I recall, looking at the, kind of reasoning the way you just described?
Yes, and that's, again, plain from all the exhibits and the amended complaint. So the amended complaint essentially says, we're concluding that there is a revocation which equals retaliation, but when you look at the factual underpinnings to support that conclusion, that's where it falls apart, and that's where the district court was proper in ruling on this on a 12b6. And then request number 8, the request for the James Diesel file. Again, the attempt here is comparing it to a completely different request, but in the pleadings, there is an explanation of why these are not proper comparators. And to go through just a couple of those, number 1, the request that the appellants made is much larger than the request that Mr. Fortini made. They specifically say the summaries of James Diesel file took 80 pages worth of information, whereas the summaries for Mr. Fortini, the officer that he requested, was just on 1 page. So here you already have 1/80th the size of the request. They have alleged that the files that Mr. Fortini requested had already been produced during discovery, that Mr. Fortini agreed to reduce the scope of his request. He initially requested 2 officers. He reduced it down to 1, and that he agreed in exchange for receiving those to settle a lawsuit, something the appellants have specifically said that they would not do. So to the court's point, or earlier, that's not a proper comparator, saying that because Mr. Fortini got treatment in one way, that would show viewpoint or content discrimination here. And then just going to what the district court really, what the district court considered for the obvious alternative explanations here, and what the court was talking about earlier, that everything that happened here was a function of the state statute. So there was an influx of requests, 18 massive requests for a huge scope of records that overwhelmed the government and took the government more than 30 days to respond. The government gave free summaries, and then when the appellants still wanted all the information, the government waived the internal cost and imposed the
So you would
vendor fee.
agree if the request here, let's assume they just had a narrow request for all the, complaints related to Officer X, and the government responded with 45 objections about overbroad and all this sort of stuff that seemed like, not way too inapplicable on their face to a request. That would you agree that's the sort of, at least it's plausible that would be a misuse of those statutory rights, and that could be a plausible claim?
Correct. The overarching argument notwithstanding, yes, I believe that's true, and especially because the Maryland Public Information Act doesn't permit objections for overbroad and things like that.
Yeah,
There are specific
I'm going back
objections
to
be
my
made. Yeah.
civil litigation days that seep in sometimes. But, not that I've ever objected
He didn't-
to
he didn't use
requests.
any of that.
So in conclusion, the district court correctly characterized this as a dispute under a state record statute and dismissed the First Amendment claims. Accordingly, we respectfully request that the court affirm the district court's decision. Thank you.
Thank you, Mr. Fox. Appreciate it. Ms. Summers?
Good morning, Your Honor.
Morning.
May it please the court. First, I would like to clarify an earlier question about whether these requests were already subject to state litigation. Only requests 1 through 4, 6, and 7 have been covered by state courts. However, they still go to show evidence of plausible First Amendment violations in the complaint. And there are 12 other requests that have not yet been litigated.
So on that point, Ms. Summers, is your position that even if those 1 through 4 and I forget the numbers that you agree are subject to state court litigation, is it your position that you can bring a First Amendment claim, contemporaneously with litigating that you can litigate in state court the statutory issues and then bring a contemporary federal court First Amendment claim for things that are in the state, being resolved in the state courts?
I would not say that, Your Honor.
Okay.
First, the primary examples of our viewpoint and retaliation claims are in other requests that have not been litigated yet. So that is where most of our
Okay.
focus is on for those claims. And secondly, it goes to show a custom or policy by municipal defendants of First Amendment violations is the purpose of including those requests.
So can a custom or a policy exist if all the evidence of, all the custom and policy is for your client's request?
There has been case law in which that has happened, where a Monell claim has passed the motion to dismiss stage with one plaintiff. For example, in Washington versus Baltimore Police Department, which was a district court case, a single plaintiff with 4 incidents over 7 years did get past the motion to dismiss stage under a Monell claim. Chen versus Mayor, there is a single plaintiff with 2 incidents. And then Owens versus Baltimore City Law Department, which was a Fourth Circuit case, also had a single plaintiff. So yes, Your Honor.
Okay.
I would like to continue discussing Monell, but I'd first like to respond to defendant's argument that this should be a state law claim. I'd like to point out that.
Well, as a general proposition, there's no right to, there's no mandate, right of access to government information of sources within the government's control, period. You recognize that.
Correct, Your Honor. We are not asserting.
That's Supreme Court authority and a good law.
Correct, Your Honor. We are not asserting the absolute right to public information. Instead, this court.
That's what that Pissarro case was about that he mentioned.
Yes, and I would like to discuss Fusaro because there's language in that case that supports the fact that when the government decides to make information publicly available, it may not, even if there is discretion in how it can disclose that information, it may not discriminate against viewpoints in how it distributes that.
So, but make sure, I don't want to hear your position there, but that case dealt with the argument or the position, the principle that Judge King just mentioned. As a general rule, you're not entitled to this information. But there's some exceptions to that, and that involved an exception involving voter roll information, I think. So how do you get past that? Do you say you fit within Pissarro, or do you say that doesn't apply to these sort of requests? You know, we kind of, asked a bunch of questions to your colleague about why he's going this route, but that is Supreme Court law, and we have one exception. Do you buy the underlying principle, and how do you get around it?
Yes, Your Honor. Well, first, I do not believe in the briefing, the purpose of Fusaro is not to make a factual comparison in the political speech and voter information, but instead, in that decision, on page 254 to 255, this court found and acknowledged Supreme Court case law that restrictions on disclosure of government-held information can burden the expression of First Amendment, burden the expression, in this case, of plaintiffs who have made speech about defendants, and then their access to the information has plausibly been obstructed because of that speech. With my remaining time, I would like to quickly turn to Monell, if I may. I see I'm out of time.
Consistent with the way I've been handling things this morning, I'll give you 2 or 3 more minutes.
Thank you, Your Honor. I appreciate that. Defendants err in saying that our complaint does not allege Monell liability. First, at this stage, we plausibly allege a condemnation theory between JA 13 through 14. We've shown that there's plausibly a widespread practice, so permanent, well settled, as to constitute a custom of obstructing records. Not just that records have been denied, but that fees have been imposed arbitrarily, communications have been delayed, there's been failures to respond, and more to obstruct access to records. We've alleged that policymakers had actual or constructive knowledge and exhibited deliberate indifference to this custom through discussing the actions of the law department's Ms. Lisa Walden and Mr. Salisbury on pages 11, 13 through 14, 17, and more, and constructive knowledge held by the Baltimore Police Department through discussing communications with the document compliance coordinator, and that's discussed on JA 16 through 17 and JA 15. So this custom is fairly attributable to the municipal defendants, and plaintiffs can plausibly establish an affirmative link between this custom of obstructing records and it violating the First Amendment rights of plaintiffs. If there are no further questions, we respectfully ask this court to reverse and remand the lower court's decision. Thank you, Your Honor.
Thank you. Thank you. We particularly appreciate the work of the Vanderbilt Clinic, and it's good to have you here. Good experience for you. Good experience for us. And this case will be taken under advisement, and we will adjourn court, Madam Clerk, until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.